What was Mr. Rankin's reaction when you arrived to the apartment?
Well, he wasn't happy. I just simply asked him, why he hadn't paid the debt back, and he got all livid and just jumped up out of his chair and reached for something on the table.
Do you remember what he said to you?
Something like, "You tell your boss that I'll kill any motherfucker that he sends after me."
Okay. And you said that he grabbed something from the table. Do you know what he grabbed?
I didn't at the time, but later that I learned that it was an ashtray. But
Okay. And what were you doing when he grabbed the ashtray?
I was leaving. I had when he jumped up and he looked angry and he made that statement, I was done, so I had to leave. And as I was going out of the door to get away, that's when I got hit in the head.
And how close was Mr. Rankin standing from you?
How far away?
Yes.
Um, when I turned, I saw that he was about 3 feet away from me.
Okay. And what do you do after you left Mr. Rankin's apartment?
Well, I was suffering a severe amount of pain, and I could feel blood gushing down the side of my head, and I panicked. All I needed to do was go to the hospital as soon as possible and get medical treatment.
Okay. And what happened in the emergency room?
Well, I saw a doctor there, and she stitched me up.
Do you remember how many stitches?
I don't. It was enough. It was 10 or 13, whatever. I don't really remember.
Okay. Do you have the intent to kill Mr. Rankin?
I did not.
Okay.
When if I had had the intention when I went over there to kill him, I could have done it when he reached for whatever it was on the table. I tried to get away. And when I was going out of the door and I got hit in the head, I thought I'd been shot. It hit me so hard that my vision was blurred for just that split second, and I thought that I'd been shot. And in that instant, I turned around and he was 3 feet away from me, right on top of me. The only option that I had was to shoot him. And if I had tried to keep running, I can't outrun bullets. So I would have been shot in the back if he had shot me. So the only alternative that I had was to turn and shoot him.
Okay. No more questions, Your Honor.
All right, before we do the cross, I just have a question. Are you sure you all didn't prepare this direct examination together? That was just out of the blue cold like that?
Yeah.
Wow. Okay. Wow. All right, who's crossing Mr. Harper?
I am.
All right, Mark, let's hear it. And I thought we had an unprepared witness that I put on the spot to play Harper, but apparently not. So
I forgot to say I shot him.
I'll be careful with him. You
So,
may proceed.
all right. So going to direct first, did you just say you didn't carry a gun you don't carry a gun routinely for your line of work?
I believe that she asked me, did I have to? And I took that as, was I required to? And that answer is no.
But you do, in fact, carry a gun routinely for your work.
I do.
Okay, thank you. So going to the evening of the killing, November 29th, if we could again, you knocked on the screen door, and after hearing no response from the two men you saw sitting at the table, you entered, correct?
Well, I heard voices. I didn't see them from outside of the door.
Let's just, it's a kind of yes or no question, correct?
It's really not, but okay.
Very good, very good. Well, what is, but in any event, thank you. So Mr. Jones had previously testified the table is about 6 feet from the door. Would
Right.
you agree with that?
Yes.
Very good. When you opened the door, did you go into the room or did you stay in the doorway?
I walked into the room.
And how far did you walk into the room?
I don't know, maybe 4 or 5 feet or so. It's
4 or 5 feet? 4 or
I
5
think,
feet?
yeah.
Okay, so that would leave you maybe 1 to 2 feet from the table. Is that correct?
Yeah, it wasn't far.
Okay. And after you entered the room, you saw two men sitting at a table, drinking and playing cards. Is that correct?
Yes.
And you could tell it was a table, right?
Yes.
And how could you tell it was a table?
Just by the observation of four legs and a tabletop.
There you go. And what made you think they were playing cards?
I saw cards on the table.
Okay. And could you see the drink glasses?
I could, yes.
All right, Your Honor, I'd like to pick up the prosecution exhibit number 4, previously entered, Mr. Harper's detailed drawing of the ashtray that was sitting on the table.
Absolutely, you may.
Mr. Harper, did you draw this rather detailed sketch of an ashtray?
Yes, I believe that is my drawing.
And did you see this ashtray on the table?
Yes, I believe so. I
Did you see a gun on the table?
did not.
Did you ever see a gun on the table or in the hands of Emil Rankin? Emil Rankin, or even in the apartment?
No.
All right, let's move on. After your conversation with Emil Rankin, he started to get to his feet and move toward you. Is that correct?
Yes, that is correct.
And after he got up and started moving towards you, you turned around and were leaving as fast as you could go out the door, correct?
I wasn't wasting any time.
Sure you weren't. Were you leaving fast when the ashtray hit you on the head?
Yeah, I believe I was.
Were you halfway out the door when the ashtray hit you on the head?
No, I had just made it to the threshold of the apartment.
Well, if I could I so so I guess I'm at a little bit of a loss. That's an inconsistent statement with his deposition.
Or well, impeach him. Lock him in. Make sure, ask him again, and lock him in to his answer today, and then ask him if he remembers giving a statement and go through the steps of impeachment with the prior inconsistent statement.
So you weren't halfway to the door.
I don't think I understand your question. At what time?
Well, so when the when you were leaving as fast as you could, were you midways through the door?
I had just made it to the threshold of the door.
So in your deposition, now do I have to enter the deposition into evidence?
No, you don't introduce it into evidence, but you would ask him. Let's do a timeout, and his answer, it sounds like right now is, but I'm a little shaky on the time frame that you're locking him into. I didn't write it down, but your question was, were you halfway through the door when you turned to leave, or?
You're correct. Let me restate that. Were
Okay.
you halfway through the door when the ashtray hit you on the head?
Okay.
Yes.
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 Okay. So we already. So you were already halfway through the doorway and moving quickly away when the ashtray hit you on the head.
Yes.
Correct.
My body was.
That's good. Thank you very much.
It's.
Did you turn back around before firing the gun?
Yes, I did.
And did you advance on the victim before firing the gun?
I did not.
Did you fire recklessly or did you assess the situation and fire at a specific person?
Did I fire recklessly?
Did you fire recklessly waving like this or did you fire at a specific person?
I turned around and shot at the person that was closest to me after I had thought that I had
Let
been
me
shot.
ask the question again. You're right. Did you fire at a specific person?
I did.
And you did not fire recklessly, correct?
I did not.
And did you intend to fire at that specific person?
I sure did.
All right. And did you see a gun in the hand of that specific person?
I didn't have time to see much of anything other than
And
the person.
did you, yes or no, did you see a gun in the hand of that specific person?
I did not.
Okay. And did you see any kind of weapon in the hand of that specific person?
I did not.
And did you aim your gun when you fired?
I don't think that I did. I think that I held it in a steady position and fired as fast as I could to defend my life.
So you didn't aim your gun. So it could have sprayed bullets anywhere if you don't aim a gun.
I'm not sure what you mean aimed. I didn't look at the front and rear sight and do a nice smooth trigger pull or anything.
But you did effectively aim the gun at the person that you shot at.
I
Otherwise-
pointed. I don't think I aimed. I pointed it.
You pointed the gun at the person. Okay, very good. Thank you. So did you fire off more than one shot?
Yes.
All right. So just to be clear, you were moving away rapidly, at least halfway through the door when the ashtray hit you in the head. And at that point, you chose to stop, turn back toward the room, assess the situation. And although you saw no gun, you pointed and fired multiple shots rather than continue on as fast as you could and complete your escape. Is that correct?
I turned around to defend
Is that correct?
my life.
Did
No,
you
that's right.
choose, did you shoot the defendant?
Connor, can I
Robin?
object to argumentative, or I don't know. I feel like I have a whole bunch of objections that I want to object to.
Save me.
There was leading questions.
Well, it's cross.
It's cross. So don't make a leading objection on cross.
Okay.
Let me hold off on the objection. We'll talk about it after. Go ahead, Mark.
Just to sum up, you fired multiple shots. Let this go. So you're moving rapidly, at least halfway to the doorway, when the ashtray hit you in the head. At that point, you chose to stop, turn back around toward the room, assess the situation, and although you saw no gun, you aimed and fired multiple shots rather than continue on as fast as you could and complete your escape. Is that correct?
That is incorrect.
And what is incorrect about it?
I turned. I didn't do a lot of assessment. I didn't look to see who was in the room and who was carrying what gun. All I did was turn in that instant because I thought I had been shot in the head. I turned and shot. I didn't look to see who was smiling at me. I didn't look to see who else was in the room pointing a gun at me. I only reacted. I turned and I shot to defend my life.
Did you just previously state that you specifically aimed at a specific person?
Again,
I
no.
mean, pointed your gun at a specific person. You did
Yes.
say that, correct?
I did.
Okay. So that's, and you were moving away rapidly,
Yes.
and you were at least halfway to the door,
Yes.
and the ashtray hit you in the head.
Yes.
And at that point, you chose to stop,
I chose to defend my life. Yes.
and you turned around and went back toward the room, correct?
I just turned.
Right. You turned around, and you saw no gun.
I didn't have time to look for
You
a
saw
gun.
no gun. You aimed and fired or you pointed and fired multiple shots, correct?
That is correct.
And you did not continue and complete your escape. Is that correct?
I did after I shot the person trying to kill me.
But you did not choose to continue your escape before you turned around and shot the victim.
No, I couldn't outrun bullets if I had been shot.
Thank you. Thank you very much.
No
Okay.
further questions.
No
Yes.
further questions.
So when you're done, say no further questions. Redirect.
Yes, Your Honor. Mr. Harper, why do you carry a gun that night?
Well, when you go out to collect gambling debts, you deal with some pretty shady characters. I carry a gun so that I don't get killed myself. I don't go out with the intention of using it, but if I have to, I will. Dealing with this kind of people, you just have to be prepared.
Okay. And so when you were turned around Did you know what hit you on the back of the head?
I had no idea what had hit me in the head. I thought maybe I got shot. I mean, the pain was so intense that it could have been a gunshot. It could have been a machete I just didn't know.
Okay. And how quick or how fast was it from the time that you were hit on the back of the head and when you turned around and shot Mr. Rankin?
Maybe a fraction of a second.
And why do you shoot Mr. Rankin?
Because in my mind, he was trying to kill me.
And one last question. What happened that caused you to react that way?
Again, I thought that I had been shot. I thought that my life was in jeopardy and I chose to turn. Had I not and kept running, I would have been shot in the back if I had been shot.
No further questions, Your Honor.
Okay, let me work backwards. Let me start with the redirect. Overall, I thought it was a really good redirect because you went in and you really clarified. There were some really good questions in there. I thought maybe it was too long. I think it was a total of 5 questions. Your last one was, you said one last question. Be very careful to ever say one last question because inevitably they're going to give you an answer that then you're going to have to ask another question. I see it in this courtroom all the time. I love it. I just start laughing. Fortunately, I love now that we have to wear masks and they can't see me laughing. But whenever an attorney says, I have one question or one last question, I'm like, yeah, right, we'll see. And it's never one last question. Yours was, so I have to give you credit for that. But I want to caution all of you not to ever say one last question because you don't know that it's going to be one last question. So try not to say that because who knows? The jury says, oh, I thought, they said only one more question and now they asked 2. So just avoid that. But there were some really good redirect questions. Let me see if I can find. I wrote so many notes for both the direct, the cross, and the redirect that I'm going to have to see. All right, there was. Oh, I know what it was. Some of those there'd be a legitimate objection to having been asked and answered on direct. Like, why did you shoot him? That's something he testified to on direct, and I don't know that that was necessarily an appropriate redirect question, and I would have sustained an objection as asked and answered. He answered that before, and it wasn't specifically in response to something on cross. I don't think. It may have been, because there were some things that Mark did a good job when he ultimately broke it down. I didn't like that question the way it was the first time, Mark, that there was an objection as being argumentative and perhaps it was compound, but you came back and you cleaned it up and I thought it was effective the way you stopped after each. One of the things we have to note here is that even though he won't admit to being prepared, Scott was a fantastic witness on both on direct and on cross. So he gets an A+ for his witness testimony. Fortunately or unfortunately for him, you don't get graded on being a witness. But if I graded you on a witness, Scott, you get an A+. So let me finish with the direct, and then Scott will get to the cross. In the beginning, Anna, I don't remember exactly. I think you asked him to state his name and spell his last name, which, yeah, I've told you all to do that. But I would prefer, and if you have Judge Nazarin and he is going to hammer it, and it doesn't hurt, and I'm watching my attorneys in the courtroom stuff, and a lot of them do this, just your first question, could you turn and introduce yourself to the jury? And when you prepared with your witness, they know what that means. They're going to introduce themselves and say, I'm so-and-so, and, whatever else. Now, I wasn't sure at first. Your next question to him, after you told him to state his last name and spell his last name, at first I wasn't sure, but afterwards I liked it. Oh, why are you here today? I've never seen that before, but it worked. It worked because he was a good witness and he gave you a good answer to that. So it worked out. Why are you here? Because I've been falsely accused or whatever. And so I like the way it played out. When I first heard the question, I was like, I'm not sure about that, but it seemed to have worked out. You had a generally conversational direct examination, which is what we're looking for. It should be a flow of information that you all are like having a conversation. Oh, yeah, there was a very like, and he answered something and said, "Do you remember?" And boom, he gave you an answer. So I thought that it was a good, particularly for not practicing this with him. You weren't even sure who your witness was going to be. I know you prepared questions, but you hadn't gone through a walkthrough. I want you all for next week to work with your partners in walking through. It was more difficult this time because I just randomly assigned people, and these aren't necessarily who your partner is going to be, who's going to play your witness next week. But in prep for next week, I want you to meet with them. You can do it virtually, but go through the questions. Do a trial run through with your partner so they know what questions you're going to ask, and it goes smoothly. He ended up as if I cannot tell that it wasn't prepared and you all did that because he was a good witness.
Well, I got to say, I feel beat up. Mark had me in the corner beating me up, and I was like, just short of going.
Yeah, no, Mark, let's go to the cross. It was a good cross. It started out very leading questions. Then, Mark, though, I wrote down, you asked a lot of them, did you see a gun? That can be turned around. That's an open-ended question. Turn it around. In fact, you didn't see a gun. And why do you know that? Because of his statement or because of the facts. So there was no gun. So what else can he answer? And then you could just make that question, as well as a number of the other ones, leave off the did you and make them leading where you just put words in his mouth and there's nothing else he can do but agree with you. So instead of did you see a gun, in fact, Mr. Harper, you didn't see a gun. And then he's going to say, no. I mean, what else could you say, Scott, to that question?
There's
There
nothing.
was no gun, right? And then I
How
would
do
follow
I-
up with that. What's that, Mark?
How do I know he didn't see a gun?
Well, there's nothing in the about a gun. You've got his statement that he made. He doesn't say anything about a gun. So if he was to say there was a magical gun now that nobody recovered, then you could beat him up with, you've never mentioned that, or you didn't mention that in your statement. Don't we have a statement from him? And he doesn't mention anything about a gun. So you can presume from that if ever there was a time for him to talk about the gun that he saw, it would have been in that statement. So the failure for it to be there, I think you're safe in making the assumption and then just going right at him with, in fact, you didn't see a gun. And then I think he's going to say, no, I didn't. Otherwise, we got a whole nother area that we can get into with him. But then I'd beat him up with a statement if he says, yeah, he saw a gun. But then I would follow it up with, and that's because, Mr. Harper, there was no gun that Mr. Rankin had. In fact, Mr. Harper, the only gun that evening was the one that you brought to the scene, isn't it, Mr. Harper? And that's a gun that you don't have a license for, do you? So you're just beating him up with words that he just really can't do much. Now, I know he would maybe try to wiggle a little bit of some of these. Well, I don't know what I saw. Well, but for sure you didn't see a gun, did you? Because if you did, you would have told us about it before. If he wants to wiggle down that. I don't know what was going on. I didn't see anything. Okay, you didn't see anything, and part of that not seeing anything is not seeing a gun, isn't it? So just keep at him if he tries to worm, just go at him. Now, but here's what happens with it. It was too long. It was more than 10 minutes. And there was a lot of back and forth. Let me see. Let me just look at my notes. I had be careful. Oh, yeah. You asked an open-ended, a terrible open-ended. You made a statement and it had a couple of different things in it. And you said, isn't that correct? So that's not open-ended. That's a tight, closed-ended question. But it had a number of things, and then he said, no, that isn't correct. And then you know what you asked him?
Yeah.
What isn't correct about that? Boom! Go ahead and just come down and tell us. And he did a good job of. So that's an absolute no-no. But this is where, Mark, you really came back to it in the end, and you broke up each thing, and you got him to agree in pieces to a number of those points that you were trying to make, and I thought it looked good there. I don't remember if ultimately there was something that he tried to wiggle on, but I know that you got a number of the pieces individually that you didn't get when you tried to do a long, and you did, and A and B and C and D and G and E and F. Isn't that true? No.
The reason I did that is because I'd already asked those questions once before, so I didn't know if I could kind of re-ask them, but I guess I could have.
Well, I mean, there could be an asked and answered objection if you had already asked them. I didn't realize that, but it really sounded like a closing argument. It sounded like you were putting together your theory in the question. If you've got those answers already, you've got them on your pad, and then you argue that to the jury in the end. He didn't see a gun. He didn't, whatever those points were. They were good points, but stay away from compounding them together. And then if there's one ever so slight thing wrong with it, he says, no, that's not true. And then never, ever ask the question, no, so what's not true with it? Because that just opens the door. And then if you tried to object, it wasn't a leading question, which there were a number of times when you asked a leading question and he tried to wiggle, you cut him off, which is good. It shows control. But there was one that you didn't even let him answer. You made a statement and then he started to answer and you cut him off before he even answered. So you were so into you had gotten so wrapped up in, because you knew, you expected him to run and you expected him not to give you a yes or a no, and you didn't even let him answer. So be careful with that. You make comments, Mark, and I want you to go back. I turned on the recording. Fortunately, I forgot, but I turned on the recording. I want you to go back. One of your assignments for next week is to go back and watch the recording. It usually posts on the Canvas page by tomorrow. I want you to go back and watch the recording of yourself. All of you, actually, who got recorded, try to go back and watch, because you will learn so much by watching, and you'll make changes to things. But I want you to go back and look at that, and you'll notice that you make a lot of comments after answers, like, all right, thank you, there you go. He answered something and you said, there you go. And then another one was like, let's move on. All unnecessary. Just garble all that up and just throw it away in the garbage. You don't need to make any of those statements. And I think you'll see it if you go back and you watch.
That is very
hard to the next question. What's that, Scott?
That is very hard to resist.
I know. But I call them peanut gallery comments that just are unnecessary on the witness's answer. And I probably wouldn't let you get away with it in the courtroom. I'd probably call you up to the bench and I'd say, okay, stop making comments. You want to ask questions, you can ask questions, but don't make comments, on the answers or make, some people, it's just a nervous habit and they'll say, okay, after every answer. Completely unnecessary. That's not what you did, Mark. I don't think it was a nervous. I think you were trying to reiterate and stuff. Or I don't even know if you knew that you were making some of them. Like,
well, so let's move on. I was trying to do a signpost thing, saying we're going to something different, because you always do that. I mean, I thought the book said it, but maybe not. And the other statements were an attempt for me to look a little less combative, but I guess I don't need to do that.
Yeah, no. I mean, you saw how I said I would have went at him. I mean, this is the killer, man, and you're the prosecutor, and this is one witness that you can beat up. Usually, I mean, there are some exceptions to that, but I don't think that you need to try to add comments to look less combative. You don't want to be overly aggressive. Maybe, and even my example of what I would have done might have been a bad example as overly aggressive. That if I was critiquing myself, would have said, no, okay, back it down a little bit. But what's the purpose of there you go when he gives an answer?
Nothing other than being congenial.
Okay.
And actually, at that point, he had just made a statement that was incorrect, and then he corrected himself. And that was my point, is there you go. You got it right. Thank you very much.
You're cheering him on, but there you go. See, I knew you could answer my leading questions. Unnecessary. Okay. Avoid that. And I mean, it got to a point where it was after every one. So if it's a transition, which I agree, and I think that's what you talk about in the book, there are, nice times to make a transition to a different topic, but I don't think you're making a transition after every question. I think each topic should have a couple of questions and then maybe a transition. Just go back and watch it on the video. Okay, here. I mean, I think I already talked about it a little bit, but the two questions that you asked, and these were, same topic. Did you see a gun? Did you ever see a gun? I agree with that point, but just turn those around, and that is, you didn't see a gun, and then let him answer, and then follow it up with, in fact, you never saw a gun. See, so you're making the same point as I'm trying to make there, but you're asking it, did you see a gun? Did you ever see a gun? And I'm simply saying, turn that around into a leading question. You never saw a gun. In fact, no, you didn't see a gun. He answers, and then you say, in fact, you never saw a gun. Two very good points that now you're saving for closing. Did you fire recklessly? Again, that's not a leading question. I'm not sure exactly where you're trying to go with that, but decide where you're going with that and then put that in a leading question where it's just, you're making the statement rather than asking. See, that's the mindset that I want you all to be in cross-examination is you're not asking, like, did you fire recklessly? Even though you know the answer is going to be yes or no, whatever. You simply convert that into a statement. In fact, you fired recklessly, if that's your point, and you know that you're gonna get him to start. But I don't think he was. What was your point, Mark, with that? Did you fire recklessly? Is it your?
I was ready to use either answer actually. So if you said he's fired recklessly, I'm gonna say okay. So you were it was basically going to the point of being wanton, being reckless with human life. And if he says no, then I'm going to say in one of the follow-up questions that you didn't fire recklessly. In fact, you assessed the situation, you took time, you aimed, you had all this, you had, it wasn't it all didn't occur in a second. You made a conscious decision to turn around and then you thought about it and you
okay.
took it.
And I see that, and sometimes, I mean, I will allow you to ask a question you don't know the answer to, and it doesn't matter. You can go either way with it. So I accept that. But what does it matter? How does, if the defense here is self-defense, what does it matter if he intentionally aimed and shot the person who he thinks through the ashtray that he don't want to admit as an ashtray, but caused the harm to him, whether it was reckless and accidental or whether it was intentional? How does that take away from the defense of self-defense?
Well, if he admits to recklessly shooting in the room, that's no longer self-defense. You're not defending yourself against an individual person. You're committing second-degree murder.
Right.
It's reckless disregard of human life. And so
I
at least got him on that.
Yeah, no, okay. All right. So that's what I wanted to hear you say, that so you've locked him into a lesser included if he says that. But are you willing to, take that risk and come away from your first degree as charged? Those are decisions, and you're obviously well prepared. You gave this a lot of thought. No question about it. You thought out every question, and you have an answer for that. It's a strategy, and if that's your strategy, that's fine. Just be prepared, just in case the judge next week asks you that. Be prepared to respond with that. If it's Judge Nick and Judge Nick is giving you a hard time and saying, why'd you go with this? Why'd you go with that? If you have answers for it, well thought out answers, those are strategy decisions that attorneys make every day. And I appreciate and applaud you for making those strategy decisions. And I don't disagree with what you said. If he says he just recklessly was firing, then yeah, he's essentially admitting to a second-degree murder. under those circumstances because he hasn't identified a threat that he's trying to stop, and he backs out of self-defense. So if that was your intent to get him by that question to admit to second-degree murder, it's brilliant. But he's admitted to a second-degree murder, and now you're going to have to, probably stick with that than with trying to prove the first-degree murder, because there goes the intent, the premeditated design and intent. But I don't know. You might be able to argue both or alternative in your closing. Let me just see if I had some other notes. I let him answer. There was that one that you didn't answer. Oh, I know. Here it was. The impeachment. You appeared ready to impeach him on what you thought was an inconsistent statement. But the problem was it wasn't specific in the lock-in. It was, weren't you halfway through the door, and then there was kind of some loose edges there. And he took advantage of that, saying, well, I wasn't halfway through the door the whole time. There was a course, there was a progression of this. So I don't know when you're talking about it. He took a very skilled witness, he decided to be and not agree with you. So then you were like, oh my gosh, I'm going to impeach him because in the statement it says he was halfway through the door when he got hit with the ashtray, but you hadn't included that in it. So that's where I kind of did the timeout stop, and then you were very specific. You realized, and then you asked him specifically, were you halfway through the door when the ashtray hit you? And I'm not sure exactly how you asked it, but I should have, when I said, were you, there I go, not asking it in a leading. In fact, you were halfway through the door when the ashtray hit you. So that's the full evolution of making that a leading question. And when he heard that, when he heard the halfway through the door, Scott, what was your answer?
Honestly, I don't even remember. I think
You
that
conceded it. You when he said, excuse me, because your response before was, I at what point was I halfway through the door? And that was a good point. And then that's where I jumped in because he was trying to impeach you, and I said you need to be more specific. And then he said he added the halfway through the door, and you conceded it, right, Mark? When you added that, there was no opportunity to impeach him because he actually agreed to it.
I think I asked the question right the first time. He got clever, and then I got panicky and messed it up. And then you stepped in and helped out. Yeah, that's right.
All good thoughts, though. I mean, definitely, like I said, well prepared. Be careful, though. My concern with you is that you are so dialed in and prepared and don't want to leave out anything. It's too long. And I'm concerned that you're going to run the risk on your cross of going too long. Pick out a couple of home runs. Pick out 3, maybe 4 really good points, and then design 2 or 3 questions to get the setup and then the hit over the fence, and then move on to the next. And boom, 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 3 or 4 of them, and then it's going to get you in well under 10 minutes, and you'll be able to make those really good points with the witness. So it shows great preparation, great comeback. I mean, you're listening to his answers and you're rolling with him. I mean, it was like a scuffle, which it is. It's a cross-examination, and make no mistake about it, this is the most important witness. This is the witness that the prosecutor makes his case on. You rarely get this opportunity. Normally, the defendant does not testify. In my case today, we had to take about a 30-minute break after the defense had presented all their other witnesses because he wanted to testify and the defense attorneys did not want him to testify. And so they were going back and forth, not yelling and screaming, but just talking and needing more time to talk him out of testifying, which they did. He didn't testify. I think that their manslaughter was a victory for the defense. It was a clear victory for the defense. So maybe if he had testified, it would have been second-degree murder in my case. But again, those are strategy decisions that you make. Here, we know the defendant's going to testify. They testify, and it's the most important witness. and Mark, you were tuned into that as the prosecutor, that you got to really make your points with the defendant. All right, so good cross exam. Do we have another defense witness?
Can I ask
Go ahead, questions, absolutely.
real quick question? So, there's no reason for me to lay any foundation. My first two questions I probably could have gotten rid of. Correct. I mean, I don't need to go the night of blah, blah, blah. And then
Right.
in response, so Mr. Jones being 6 feet from the door, that in fact was not said on direct this evening, but it was in a deposition. Can I use that even though it's in a deposition?
Oh, absolutely. Absolutely.
Okay, I didn't know if I
Wait,
had it.
who's
I thought maybe
deposition?
it'd be hearsay.
No, I mean, those are facts. Those are sworn, that's sworn testimony. That's how you know what the facts are. That's why you do discovery, so that you know what the facts are, so that then when you go to trial, you can use those facts that you know to be true from the sworn discovery. And if they go a different route, you can impeach them. But whose deposition is it in?
Jones's deposition says it's table 6 feet from the door. But he didn't actually say that tonight in our trial. So I'm thinking, is that,
Okay. Well, but it's a fair question. You know from the deposition that to be a fact. If he says something different, then you can't impeach him with Jones's deposition. But if he's a truthful witness, he was there that night and he went with it. He said that's about right. Because
so I could
No.
say Jones said that in his deposition, or
no.
Jones. I couldn't
No,
say
no.
any of that because that's obviously hearsay.
No, but it's a fact that you know from the deposition, so it gives you the basis for the leading question that you ask him. Because the rule for cross-examination is you have to have a basis for the question. The example that they used in law school 30 years ago when I was in law school, what was his name? I'll remember his name. My law school evidence professor, the example that they use for cross is, you can't just say, isn't it true that you have sex with parents? There's no basis for that. But here, you know that in a deposition that Jones said that the table was 6 feet. That's your reasonable basis for it. So you can say, isn't it true? Or in fact, the table is 6 feet away. And there's no reason for him to lie about that. He was there. He saw how far the table was, and he should agree. If he doesn't, then there are ways in the real world, not here, but in the real world, where you would then call Jones as a witness, or you would ask, no, because you're the prosecution, you would have a rebuttal case. You would have the opportunity to do a rebuttal case. So if something like that comes up in your cross-examination of the defendant where they lie about the distance, you would have the opportunity to do a rebuttal case and prove it any number of ways by introducing a diagram of the scene with measurements, by recalling Jones to testify that the table is 6 feet away. So that's the purpose for the prosecution's rebuttal. If there's stuff that comes up in the defense case that now you need to go back and disprove, and you can convince the court, look, Jones is going to testify. Here's his deposition. He testifies it was 6 feet. Harper took the stand and said it wasn't 6 feet. The judge has got to give you an opportunity to have a rebuttal case and to present that evidence that rebuts what Jones did. What Harper did. Here, you wouldn't have that opportunity because he agreed with you, which I would think would normally be the case if he was at the scene, because he's got to be smart too. And he's got to realize, if I do testify and I lie and it's something that they can disprove me on, they're going to do it, and that's not going to look good for the jury. So it's not in his best interest to lie about things like that. But if he does, trust me, you would have the opportunity to request a rebuttal case to recall Jones, or to recall the officer or somebody else to testify about the distance, which is contrary to how he testified on cross-examination. So there are ways to do that. It was a good question, and he agreed with it, so you got it. But the deposition of Jones gives you the basis to ask the question. So you're looking at all the discovery, and then you're saying, These are the questions I want to ask based on what I know to be true about this case. No need to whip it out and anything like that. Just ask the question. All right, let's see. Holy cow, it's 8:41. I would love to do a closing, but I'm not. I'm going to give, because it's the very last part, we should have a defense closing. I want to hear the defense closing. Who's doing it?
Can you hear me, Judge?
I can't.
Oh, okay.
You doing the closing?
Yes, sir. I reckon.
All right, assume that I just, because you're going to in some ways respond, and I would reserve some time for rebuttal, but assume that I just thanked the jury and I went over all the evidence about how Harper is a horrible first degree planned murderer, and now you get up and respond to that with your closing.
Okay, got it. When faced with life or death, he chose to live. On November 29th, Mr. Harper had a split second to make a decision. He was forced to decide between his life or death, and he chose to live. Unfortunately, the circumstances caused Mr. Rankin's death, but that's not murder. It was self-defense. Today, the evidence did not show that Mr. Harper was the aggressor. The evidence showed that Mr. Harper feared for his life. Mr. Harper was afraid to die. He was afraid that at least one of the two men that were intoxicated would kill him or cause severe bodily harm. And because of this, he defended himself. This case today presents only one question that the law requires you to answer. And that question is, what was going on in Mr. Harper's mind seconds before Mr. Rankin's death? As members of the jury, you will look at the evidence that has been presented today and the testimony of the other witnesses. Members of the jury, in doing so, you will find three key facts. 1, Mr. Harper is a debt collector, and the only reason he was at Mr. Rankin's apartment was to collect the debt. 2, Mr. Rankin was hostile towards Mr. Harper and threw a heavy ashtray at him. 3, and because Mr. Harper was afraid and feared for his life, he acted and defended himself. Today, you heard the physician, Dr. Schultz, that treated Mr. Harper when he arrived at the hospital. We heard that Mr. Harper's injury was so severe, it was as if someone had hurled an object with considerable force. We heard Dr. Schultz say that Mr. Harper had not 1, not 2, but 13 stitches. We also heard that while he was prescribing Mr. Harper's painkillers, an officer arrived and Mr. Harper willingly left with him while he was still getting examined. We also heard from Mr. Harper himself. We learned that Mr. Harper was simply doing his job. When Mr. Rankin told him, and please excuse my language, tell Mr. Green, I'll kill any motherfucker he sends at me for his juice. Once hit, Mr. Harper didn't know what happened. He didn't know what was coming next. Mr. Harper didn't shoot Mr. Rankin because he was an innocent man. He shot Mr. Rankin because he was afraid. He was afraid of Mr. Rankin. He feared for his life, and he was afraid to die. So Mr. Harper did not want to die. He chose to live. Yes, Mr. Harper did leave the scene, but it was only because he needed medical attention. There was blood everywhere from the blow that he took to the head. He didn't flee. In fact, again, as stated, he left willingly with the officer when he was at the hospital. Members of the jury, this is my last time speaking with you. My client, Mr. Harper, is facing a serious offense. He is being charged with a violent crime. Once again, he's fighting for his life. So I ask that you consider all of the evidence and testimonies in this case. You know the facts. Mr. Rankin was the aggressor. He was a gambling man. He didn't pay his debt, and he was upset when Mr. Harper came for the money. You heard the testimony of the witnesses, and you heard from Mr. Harper himself. The prosecution bears the burden of proof. If there's any doubt in your mind about the evidence, then the state did not prove their case today. Today, you have the opportunity to learn the decision of Mr. Harper was forced to make. He just wanted to live, and when faced with life or death, he chose to live. That's all I got. Well, no, I lied. Your job here today is to hold the state to its burden and do the right thing. Okay, now that's all I got.
All right. Well, you gave it away in the end that you were reading it off the screen. You had great eye contact, so I wasn't sure whether you had memorized all of that or whether you were reading it. So you did a really good job of reading it. You gave it away in the end, though, there. But great voice inflection, great content, clear theme. You know, chose to live, and you reiterated the theme. You all tonight get away with not having to mirror the theme of your opening because you didn't know it's not your partner who's doing it. But next week, tonight, the defense opening theory or theme was not looking for trouble, but trouble found him, which is good. I like, and I really like yours also of, he chose to live. Next week, though, I want the openings and the closings to match, to have the same theme. So you need to work with your partner to know what their theme is going to be, and then you incorporate that theme into your closing in the end. So that's not bad for you tonight because you didn't have that opportunity. You had a great theme. It was great content. It was a really good closing argument. The only thing I would add to it is a little bit more of the jury instructions. I would refer to the instructions and the elements and the self-defense law. I would be very specific on what the law is and how not. Be careful. You didn't talk about this, so you didn't do this. You didn't accept a burden that you don't have. Be careful not to accept a burden. If the jury gets instructed on self-defense, then it's the state's burden to prove beyond a reasonable doubt that it's not self-defense. But go over those elements that they have to disprove of self-defense and use the specific jury instructions and talk about how the evidence applies to that. Here's the self-defense jury instruction. The defendant is not the aggressor. Gives you a lot of opportunity. He's not the aggressor. Why? Because Mr. Rankin threw the ashtray. He drew first blood. So when you deal with that, who the aggressor is, you're showing who the aggressor was and it not being the defendant. The next one is defendant under reasonable belief that in danger of great bodily harm. We'll talk about how and why he is under how and why the state hasn't proven beyond a reasonable doubt that he wasn't under a reasonable belief of danger of great bodily harm after an ashtray had split his head open and he was bleeding profusely, for which he needed to go to the hospital and get X amount of stitches. So you're working the facts into the law. So use the jury instructions, but don't misunderstand me, Khadija. It was good. It was better than good. It was a really good content-wise closing argument. I'm just giving you a couple of suggestions, and kind of along the same lines as Judge Ward had said, where we understand you're going to read some. If the judges catch you doing that, though, I mean, if you could boil it down instead of word for word, and maybe could put some sentences or some paragraphs or some other things that you can have right in front of you and you can look at, but then that triggers a lot more content that's coming from your head. So that's going to not appear like you're reading it. And that applies to everyone, because I know that temptation is to be there. I do it now. I mean, I when I have Zoom stuff, if it's something I know, I'll make a little note and I'll put it on my screen and I'll read it, but it looks like I'm looking into the camera because I posted the little note right underneath the camera. So tricks we'll all learn in Zoom, but you will never get away with in the real world. In order to do that, to read it in the real world, you're going to have it in front of you. So I don't want to see any reading. My last thing, everybody, really good job tonight. And that's essentially how it's going to go next week, except that everybody's going to be, each team are going to be in different rooms with different judges. You're going to be with your teammates, and you're going to hopefully, between now and then, practice with your teammates each of the things, because they're going to play your witness, so you're going to have practice that. You're going to know what their opening is, so you're going to incorporate that into your closing, your themes, and all of that. What I want you all to do, I know you've done it before. We've done it together. But between now and next week, it's plenty of time. I want you to go watch one more law school level mock trial competition, just to make you relax more and watch how they do it. Watch how smoothly, because at that level, at the trial, the final competition or whatever, I mean, they are so well polished and prepared. So just watch them, because theirs is exactly like our trial is going to go. A 2-hour trial with 2 witnesses. All of the competitions, law school competitions, follow that same format. So watch one more between now and then to give you that final sense of, okay, I know now after seeing a competition team do it, how I'm supposed to do it. All of you are doing great. Don't get me wrong. If you have any questions, don't hesitate to email me, text me. Please use, though, my office email address, the fljud13.org. But you have my phone number. Don't hesitate to text me. I will get back to you. You know, any questions you have, don't hesitate to ask me. We're over time tonight. I thank you all. I appreciate we didn't do any breaks. We covered a lot of stuff. You got to meet one of the judges that's also going to be judging you. I think that was a good thing for you. So thank you all very much. I will see you next week.
Thanks, Judge. Good night.
I have a question.
Yep. Let me stop the.
All right, we just started the recording, and I'm looking at the sign-in. There's 9 people. I'm going to go ahead so that I can get credit to those that are here, and then I'll go back if anybody's signing in late, and go down the list and try to get an idea of who is here and who isn't here before we get started. I've got a lot of material. I know we got cut short last week. Not that it wasn't good, but Judge Nick came on, so I didn't finish everything I had. So the first thing we're going to do tonight is we're going to go back to some of the objections, because they are very important, and I'm going to share something with us that I think is entertaining and educational. So we'll do that too. I'm talking a lot because I'm hoping the number of participants goes up as I'm doing it, but it doesn't look like it is. At 6:03, I'm going to start going down the list. Victoria, I'm sorry, Lucero. Lucero here? No. Victoria Bowers. Cindy Boone, I see your name on there.
Here. Yes, here, Judge.
All right. Hello. Scott, I saw Scott?
Yes,
Yeah, we talked. You yeah, but
can you hear me? See me?
Yanesi.
Oh.
Yes. Some of you are going in and out. I'm not sure.
It seems like you are going, like we can't see you, and you seem like you're cutting out too occasionally. I don't know if anybody else is experiencing that or what, but
Can you see me now?
I can see you now.
All right. All right, I don't know how, if I'm cutting out, let me know. What happened is a couple of you, I could see your faces, and then it started like a circle spinning where your face was. So I don't know what's going on. I'll try to keep going, and we'll see if we continue to have some technical problems, what I can do. The important thing is that you can hear me right now, and then ultimately if any of you are giving your opening statements, that I can hear you. And sometimes it's a problem because not everybody is muted. It looks like most of you are. Jonathan, if you can mute, I can mute you. All right, that might help. I'm not sure. Let me just keep going with Yanesi. Were you here? No, Yanesi? Elaine.
I'm here.
All right, Kiona. I see your square. Can you hear me, Kiona? if you're saying something, I can't hear you. Jonathan, I see your square, but I can't hear you.
I think did you mute him?
Um,
Because he was the one that called in and he wasn't muted, and so you said you could mute him. So I don't know if that's the issue or not.
it might be. I'm trying to. I don't think I can unmute him. Maybe it's my computer. But well, the good news is that Joey, you can still hear me, so that's a good thing. Let me keep going, and I'll come back to that. Mark Langenkamp. I don't see a square. There you are. I see you, Mark. I tell you what I'm going to do. I'm marking those people that I see your name on there. So don't worry. If your name is on there, when I call your name, I look up and I look at my squares, and I'm marking you. If I don't know why I can't hear you. Shaquan.
Present, I'm here.
All right, very good. See, that one worked perfectly. I can hear you. Anna Reyes. Anna Reyes. No. Joey, I know you're here and we can hear you. Let me just try again, make sure I can still hear you.
I'm here.
Now, I'm wondering, there's though on your square that's on my screen, there's a little orange triangle, as there is on 2 or 3 other people's. Now I can see you live, but before it just had a picture of you and there was an orange triangle, like a.
Yeah, so that happens when I don't it's usually the other person's connection, but usually that happens when mine if I'm having that issue, it also shows it on mine, the triangle. So it might be on your end. So
All right. What I may end up doing is moving. That's why I do it from the office, but I had to come home for something tonight, so I'm doing it from home. But maybe if I move locations, it'll work. So let me see. Let me just go through the rest of the list and see who can hear me. I don't see any more triangles right now, and I can see you. Diani. No. Denise Sutters.
I'm here, Judge.
I see you. And you can hear, I can hear you, and you obviously can hear me. That's perfect. That's good. Khadijah.
I'm here, Judge.
All right, that worked well. I can't see you, but that's fine. I can hear you, and it sounds like there you are, and you can hear me. So,
Judge, I'm here. My name is Deani Stewart.
okay, Deani, I got you. No problem. Yanesi, did Yanesi join us? I see Mark.
Present.
All right, perfect. And you can hear me. So that's good. So maybe the technical issues are resolved. I was just going back to see who else. Lucero join us? No? All right, well that works out because it says there's only 12 people. There's supposed to be 15, so we're definitely missing a couple of people. They may join us. If you are not hearing me, I'm hoping that all of you can hear me right now. I'm opening up my chat box. Just at least send me a chat or those of you whose pictures, they're going in and out. All right, we're going to take a short break, and I'm going to relocate. One time that worked. I moved my computer, and it worked. Let me just check my battery, see how far I can go. All right, we're going to take a short break. I'm going to turn off my video and mute myself. And when you see me again, I'm going to be in a different location, and hopefully that'll take care of everything. So I'll see you in just a few minutes. All right, can you hear me?
Yeah, we can hear you.
Okay, I seem to resolve the issues. The location must have been a bad connection in the office in my house. So I'm actually now in my daughter's room, who's a Cooley student who is online every day in class and doesn't seem to have any problems. So this should work. The lighting is terrible, and I know you can't see me the same way, but it'll work. The
We
bad
can't
news
see you at all.
you can't see me at all?
I can't.
I can see you.
My Cooley student daughter is here to help me.
I can see you, Judge.
Okay.
It's
Joey,
my end.
you still can't see me?
Nope.
Mark, can you see me?
I can see you. I can see you.
All right. The only one's having a problem is Joey. Joey, that's you. That's on you. Everybody else can see me. Everybody who's important can see me. All right. The bad news is I had all my stuff spread out perfectly on the desk in the office, and in haste, moving in here, I just scooped it all up and brought it. So now I've got a stack of stuff that's completely out of order. Oh, I know one thing I need. Christina, I need to plug in the computer in here. Otherwise, it's going to die before the end of class. And I don't know where she plugs stuff in. But, so I'll just grab stuff. Can you plug this in? I don't know where your plug is. Thank you. All right. I'm back on track. And can you turn the fan off? Oh, yeah. Okay. Last week, we ran out of time. We were talking about objections, and I'm going to pick up there. But before I do it, I want to share with you something that one of your classmates, William Campbell, shared with me. Yeah. It's all right. And that is a YouTube video on objections. And they're made by a real attorney, but it's while he's watching and stopping, freezing a movie called The Exorcism of Emily Rose, which is a movie that I hadn't heard about before. But watching this little clip that he objects to, or he does commentary where the attorneys in the movie make objections, and it is entertaining and educational. So I'm recommending it, and we're going to post the link to it on here. We're not going to watch it during class; we just don't have time. But I am going to recommend that you watch it, and I think that it'll be both entertaining and educational for you. But the movie is about a preacher who did an exorcism and the little girl died, and he's being prosecuted for the murder of the little girl, or for her death, for causing her death. So I haven't seen the movie. It's on my list now. I'm going to go watch it. But this is a neat little thing where an attorney is kind of narrating the trial, and he'll pause it when an objection is made, talk about the objection, talk about maybe whether that was an appropriate objection or what objection should have been made. He'll pause it at other times where no objection is made and suggest what objection should have been made. I watched most of it, and I agree with most of it. Okay, so I think that it would be a good exercise for you to watch. It's a perfect example of that there are so many resources out there that you can find stuff. But I want to go over some with you that we started last week, where I can hear you all respond, and we can talk about whether it's an appropriate objection or not. As I'm going through my stuff, I found a book that I have on the bench with me. It's Florida Trial Objections. It is by, this is an old one, it's third edition, but it's by Charles Earhart, who also writes a bigger book in Florida on objections, which most judges in Florida consider to be the Bible of evidence and admission of evidence in Florida. It's got everything in it, and we keep it on our bench, and when we have an objection that we need to look up something about, we go to it. So if you're going to practice in Florida, what I'm getting at here is if you're going to practice in Florida, I strongly recommend that you buy the Earhart on Evidence book and you use that on a daily basis. We do. All right, so let's see where we were. That's my list. All right, here's the question. Did you see what happened on July 31st? What's the objection to that? Vague. That's a vague question. It just picks up in the middle of, did you see what happened on? There's no direction there for it, so that would be a vague objection. And ambiguous. Vague and ambiguous is, I think, the title of it. Here's a better example. It's a different objection, but let's see. Mr. Flinch, how did Mr. Potter respond and react when you caught him standing next to your petrified cat? Any ideas of what objections you might raise to a question like that? How did Mr. Potter respond and react? Are they asking for two things there? If they're asking for two things in the question, what's a possible objection to that question? Compound question. That sheet, I'm going to change to a different sheet because that sheet doesn't have my references back to each of the rules that we can discuss. I know I have to be getting close to the document that I'm looking for. Or I've lost it. How do I lose the most important document? All right, we'll wing it. We'll get by without it. The one that I used last week. All right, let's do it this way. What is the objection that you would give if the question has already been asked? If an attorney asks the same question twice or multiple times, what's the objection that you would raise?
Cumulative.
There's a specific objection, and you all should have a list of the most common objections. And this one would be asked and answered. And what the rule says is that it's unfair to allow counsel to emphasize evidence through repetition. Greater leeway, however, is given on cross-exam, but be especially ready to make this objection during the redirect examination. What happens a lot of times is they'll get the information out during direct examination, and then they'll go get, it's favorable information, they'll go get the same information out on redirect examination. At that point, it would be appropriate to make an asked and answered objection to that information. And if it has been answered before, hopefully the judge will sustain that objection so that the attorney doesn't get to emphasize the important answer multiple times. That's the idea behind that objection. Let's see. Hearsay is one of my favorites and one of the most common that you're going to see quite a bit in the real world. And hearsay, as we all know, we learned in evidence, is by definition an out-of-court statement being offered to prove the truth of the matter asserted. One of the most common responses to a hearsay objection is that it's not actually hearsay. It's because it's not being offered to prove the truth of the matter asserted, and therefore it doesn't meet the definition. It's not hearsay. Now, if it is being offered to prove the truth of the matter asserted, and it is in fact an out-of-court statement, then it meets the definition of hearsay. But what's the way to get around it if it's actually hearsay? Is there a way around it? Anyone? Anyone recall the hearsay exceptions? There's plenty of them. In the federal rules, they are found at Rule 803, which is exceptions to the rule against hearsay. And in the federal rules, there are, I believe it's 23, actually 24. Well, 24 is other exceptions. There's 23 specific exceptions to hearsay. And if you're a good attorney, chances are you can figure out an exception to the out-of-court statement that's being offered for the truth of the matter asserted. It could be any one of those 23 things that are exceptions. We'll look at a couple of those right now. And these are pretty common. So let me give you a factual example and see if you know what exception. We'll walk it through. The question is of the witness, and they're asked what they did when they saw the incident occurring, and they say that they called 911. Now, that's not hearsay to say I called 911. They're simply describing what they did. But what's the next question that's usually going to be asked of a witness like that? Anyone? What would you ask next after the witness testified? This is an eyewitness, and they said they called 911. What's your inclination of the next question you would ask them? What did you say exactly, William? What did you say to 911? And that's when the other side is going to jump up and object, because what they said to 911 on that occasion that was out of court was an out-of-court statement. And they were describing what they saw. So chances are it's going to be offered for the truth of the matter asserted. I saw the man shoot his wife, or the woman that was next to him in a murder trial. And that's important information that you want to get this eyewitness to testify about. There's another way to get that. You can ask them, what did you see? And you don't have a hearsay issue there where they're describing what they saw. But a lot of times they want to get in the 911 call. And you might ask before the 911 call, what they said, or you want to introduce the 911 call. In fact, I see that in trials all the time where they're introducing the 911 call. And you can make the same objection to the call coming in. It's hearsay. They're going to play an out-of-court statement, a conversation between the eyewitness and the 911 operator describing what they were seeing. It's hearsay. It's being offered to prove the truth of the matter asserted, and it's not a court statement. All right. So those of you who have your federal rules in front of you or are familiar with you've already done it. Deani, excited utterance will be the exception. You're way ahead of me, and that is under 803 subsection 2 is excited utterance, and it says a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. There's another one that I think also applies, and it's present sense impression. And that's a statement describing or explaining an event or condition made while perceiving the event or immediately afterwards. And those two are very close, and I think they both apply. And I see a lot of objections, hearsay objections that come up in court where either one of those would get you the exception and get the evidence in. So you can see from the second one, it requires the excitement. The first one doesn't require the excitement. But if you're talking about a 911 call, something that they witnessed a murder, they witnessed an aggravated battery and an assault take place, chances are you're going to satisfy the excitement element as well, and both of them would work. Another common one is, let's see what number it is. It's statement of a party opponent, where the state wants to get in the statement of the defendant's out of court statement, and it's not hearsay. Because it's a statement against interest of the defendant. Well, 80, it's under 804, I think. 804 is additional exceptions to the rule against hearsay, and former testimony is one of those that we see. Here it is, sub 3 of 804, statement against interest. Statement that a reasonable person would have made only if believed to be true, because when made, someone else or to expose declarant to civil lighting in here is terrible. Statement against interest. A reasonable person would have made only if believed to be true, because when made, it was so contrary to the declarant's proprietary or pecuniary interest, or had so great a tendency to invalidate the declarant's claim against someone else, or to expose the declarant to civil or criminal liability. So it's something that somebody wouldn't say unless it was true, essentially. And when you look at all of the exceptions, that's the one thing that we have that is the basis behind the exceptions. There's something that independently verifies the credibility of that statement, because hearsay is something that you didn't get to see them when they said it. They're not saying it under oath in court, so they're presumed to be untruthful unless there's something that satisfies gives rise to the truthfulness of it. So if somebody says something that's against them, I did it, I shot her, along those lines, they wouldn't say that unless they did it. It's against their interest to say that. The other one that comes up along those same lines is a dying declaration. And a dying declaration is the last thing that somebody says. It requires that they believe that their death is imminent when they say it. And who's going to lie right before they die? They're more likely to be telling the truth as they're dying than if in a different circumstance. So the rules permit that. The rules recognize that what somebody says while they're about to die, or while they believe that they're about to die, has some inherent credibility to it that will allow an exception to hearsay under those circumstances. But one of the things that comes up is, what if they don't die? I've had that come up before, where the state is trying to introduce a statement of a victim that they made at the scene. They might have given the description of or said who shot them, and they try to elicit, then they don't die. And they try to elicit that from the victim at trial. What did you tell the police officer, or what did you tell the medical personnel when they got to you? I told them that John shot me. Can that come in from the person who didn't die? It actually can, but what you have to prove is that at the time they said it, it was reasonable that they believed that they were dying. So we got to look at the totality of the circumstances, and it is, as William has indicated in the chat, that the standard is the belief of imminent death. If they believed that they were dying, it does still come in, absolutely. That's very good on that. Another one that comes up quite frequently is it's a statement for to a doctor for medical treatment. I know I'm not saying it correctly, but the inherent credibility of that is that you're not going to lie to a doctor when you're seeking medical treatment. You're more likely to tell them exactly what happened or the truth in order to get proper treatment, because it's not in your best interest at that time. If you're seeking medical treatment, it's not in your best interest to not disclose the truth to the medical doctor. So they recognize that as an exception. I can find my list of common objections rather than relying on my memory of which ones I see a lot. This is the document that you all have posted on the page. Argumentative. You can't argue with a witness if they're simply trying to, and it comes up two ways. It comes up, one, in that it's an argumentative question. Isn't it true that you did this because you didn't like the victim? That's argumentative. Now, I will tell you that a lot of times people will get away with that, but technically that's argumentative with the witness. But if the witness is giving you an answer that you don't like and you're trying to change their answer, that can also give rise to an argumentative objection. Calls for a conclusion is a common objection, where the question is asking the witness to sometimes invade the purview of the jury. It's a ultimate issue in the case that the jury has to decide. Was the defendant negligent? Asking a witness that. Well, that calls for a conclusion. It actually calls for a legal conclusion of negligence, and it invades the purview of the jury, who has to decide at the end of the case whether the defendant was negligent. Immaterial. Anything that is asked of the witness that is not, let me read you what immaterial, it's interchangeable with irrelevant, but it would not tend to make a fact or consequence more or less probable. And that's a fact that's critical to the case. If it has nothing to do with the case, it doesn't have to be critical. I take that back. But if it has nothing to do with the case, then it can be irrelevant. Relevance is defined in 401, and the specific definition of relevance. Let's turn to 401. Evidence is relevant if it tends to make a fact of consequence more probable or less probable. So it has to be of consequence. That's the word that I was looking for. So if it doesn't, then you can make an objection that it's not relevant, along the lines of that relevancy. Are there questions? I apologize. I'm discombobulated because I lost the order of everything the way I was going to present it. So I don't like the way it's coming out. So I'm going to move on from objections. I may come back to it if I find the document that I was looking for. But what we're going to do now is I'm going to open up the floor to opening statements. The assignment was to write an opening statement, whether you were the prosecutor or the defense. And I know that a number of you, because I've exchanged emails with you, and I know that you've been working on this, that a number of you have written opening statements. I would prefer that you turn on your camera. I'm not going to require it. I would prefer that you're not reading something that you wrote as an opening statement, but this is the first time. So there's a lot of leeway here. I want participation. I want you to give it a try. So do I have any volunteers for an opening statement from the Harper case?
I'll go, Judge.
Okay, who is that?
Denise.
Denise, absolutely. Now, Denise, I don't have in front of me, were you a prosecutor or a defense?
I'm prosecutor.
All right, excellent. Because normally in the real world, the prosecutor goes first. So I appreciate Denise being our first volunteer, and I know she's going to give us a great opening statement. But after she's done, I am going to ask for a defense opening statement so that it kind of goes the same way that it would go in the real world. So Denise, what would happen is this would come as you watch the mock trials competitions. The court's going to go over any housekeeping matters, any motions. We're not going to do motions in our trials, but those things would all come first, as well as picking the jury. You would have already picked the jury. But once all that is done and the trial is actually really ready to start, the judge is going to ask the prosecution if they're ready to give their opening statement. And this is where you would have said yes, and you would have come up to the podium. So I'll let you begin.
All right, thank you. May it please the court, counsel, members of the jury. Self-defense. The defendant, Wallace Harper, is claiming self-defense. This claim of self-defense is over an ashtray grazing the back of his head. There was no real threat to Mr. Harper's life. In fact, Mr. Harper was exiting the apartment of the deceased when he had to turn around and shoot Mr. Rankin with his unlicensed and illegal pistol, not once, twice, but 3 times. Ladies and gentlemen, my name is Denise Souters, and I represent the people of the state of El Dorado. I would like to take this moment to talk about the defendant, Mr. Harper. However, when he was on active duty, he was court-martialed. One can only guess why. Due to his history, he cannot obtain a gun license. Mr. Harper, or Wally, as he's known by his employer, and Mr. Hector Green, some kind of business investor who gives Mr. Harper a lot of work. Now, Mr. Harper claims that Mr. Green has some strange business associates. However, it would seem that if that were the case, that Mr. Harper would not have shot Mr. Rankin over just a small $250 debt and an ashtray. It may be that Mr. Harper, or as he is known as Wally, but this case is about the defendant, Wallace Harper, who, on the night of November 29th, shot Mr. Rankin, again, 3 times. There is no question that Mr. Harper shot the victim, Mr. Rankin. What is in question here is that Mr. Harper will be charged with murder or manslaughter. Mr. Harper wants to prove that he shot the victim in self-defense. Ladies and gentlemen, this is not the case. We have 3 witnesses to prove our case here, where we have the burden of proof. The murder and manslaughter, there is no possibility of self-defense. Our first witness, Odell Jones, who was there on the night of the shooting, will explain to you what happened, where Mr. Harper had to turn around and come back to shoot Mr. Rankin. Second, Dr. Kathleen Schultz, the physician who treated Mr. Harper, will explain to the injury that his head wasn't that deep and he could not have been shot or stabbed, as Mr. Harper suggests. Third, the officer who came on the scene was Officer Wortham. He was first on the scene at the apartment. Mr. Rankin can verify the proximity of the gunshot wounds to the victim's chest that look like target practice. Ladies and gentlemen, we ask that you find the defendant guilty with no acceptable reason for self-defense. Thank you.
Thank you, Denise. I liked it. Very good first opening statement. Let me ask you a couple of questions. What do you identify with as your theme in this case?
I was kind of thinking that I kind of went off the video that we watched. I kind of went off of her. I played off of her what she was saying. Obviously not the same thing, but just kind of where it wasn't self-defense. You know, he wasn't claiming. You know, he's claiming self-defense, and it was just an ashtray. It was kind of where I was going with it.
Mm-hmm. You did a great. Let me just tell you that. I mean, I like your style. I like the presentation. I like the content. It was really good. No ifs, ands, or buts. No questions about it. There was a couple things in there that I thought might be considered argumentative or might draw an argumentative objection. Like one can only guess why. I think that might be a little argumentative. It's not too bad. And you know, I teach my students that if you can get away with it, technically you're not supposed to. Okay, you're not supposed to argue an opening statement. But if you can get away with it, it's one of the areas where I'll let you get away with as much as you can. When I was doing opening statements, I preferred closing arguments. I really liked arguing, okay? And my opening statements were like closing arguments. And they did have argument in them. And sometimes they were objected to, and I had to redirect it. One corrective action that you can take if you get an objection during opening that says that it's arguing, you can preface it with, the evidence will show that. And that's kind of a test for you. If you can do that, then it's not argumentative. But when you're talking about things like one can only guess why, that's not based on evidence. This is your opportunity in the opening to tell the jury a story about what the evidence is and what the evidence is going to show. So I would stay away from that. It's not terrible at all. You did a really good job. I really liked your opening, but that's the one of the things I would carve out. I really like the emphasis on not once, not twice, but 3 times, and you did it twice. You did it in the beginning, and you did it again towards the end, and I thought that it had a really good impact. I recall back from when I was in law school many years ago, and one of the professors told us that a good outline for you in both openings and closings, it applies to both, but tell them what you're going to tell them, and then tell them what you told them. So it's okay to repeat yourself. In fact, following that, you might, repeat yourself 3 times. This is what I'm going to tell you. So kind of an introductory, then go through. And I like the way you went through telling them by using the witnesses you're going to hear from. Now, I think you said 3 witnesses. You confused me a little bit in that each side only has 2 witnesses. Only 2 of those witnesses are yours. As the prosecutor, it's going to be Jones, the friend, and it's going to be the police officer are your 2 witnesses. Now, you know in this class that the other side is going to call 2 witnesses, and that's the doctor, who I think you relied on some of the doctor's testimony, and that's okay, particularly for this class. You can do it because you know that the other side is going to call certain witnesses. In the real world, though, you don't know what the defense is going to do. So unless you're calling the witnesses, I would tell you in the real world not to rely on what witnesses the defense might call. So, but you didn't do anything terrible here. I just want to make sure that it was a little confusing as You presented it. I thought you were saying they were going to be your witnesses, and the doctor's not going to be your witness. The doctor's going to be a defense witness, but you're going to rely on some information you get from that doctor through cross-examination. So just make that a little clearer. Not that you can't do it. Now, you said and I like this. You said there's no question here. Essentially, that he shot him, and that's true, and that's undisputed. What you said, the real issue, and this is where you're narrowing the focus, and I love that because I think a lot of times attorneys lose that ability to narrow. They just do this shotgun approach. This was a murder, and we're going to prove a murder instead of focusing the issue. The issue here is really whether it was self-defense or not. The way you said it, though, you said the only issue here is whether he will be charged with. And I think you said murder or manslaughter. I can't write fast enough to write down everything. So I make cryptic notes and I go back and try to recall what was said. Now, you decide what to charge him with. He was charged with first-degree murder. There are lesser included offenses of manslaughter, and that may be an issue for the jury when they raise their defenses for the jury to ultimately decide. But he's already been charged. So you can change that ever so slightly. The only issue is here is whether you're going to find him guilty of murder or manslaughter. And that's another one where I thought it might be a little argumentative because there is the option of them finding him not guilty, and you're trying to limit it to the only thing you're going to decide is murder or manslaughter. So you've already predetermined that they're going to find him guilty of one. So be a little careful with that. The probably most correct statement of that is the only issue here is whether you find any justification for the 3 shots that he fired or, the killing of, because nobody can contest that it was killing. He was killed. But it's not murder if it's justified. So the only issue for you to decide is whether those 3 shots were justified on that evening or, however you want it, whatever your own style is. Descriptive and dramatic that you want to use, but that was something that I saw. Okay, I know what I thought was argumentative is after you posed the question, you came back and answered it and said that was not the case. That's argumentative. Okay, so I would definitely try to leave that out of your opening statements at least at this stage because you could draw an objection and one of our judges could say, yeah, that's argumentative. Write it down and take a point off of your opening because the main thing that we're looking for, the basics here are that you eliminate any argument. And a good way to do that, and I don't want you to do it for absolutely everything, to actually say it, but to ask yourself the question of the evidence will show, and then, the evidence will show that, and then what the testimony is going to be. And you did it perfectly fine by going through each of the witnesses and what the witnesses are going to say. That's the way I used to do it because that's an easy way to remember. If you're familiar with the witness's testimony, you can get up and you can give an opening statement witness by witness without any notes, looking at the jury in the eye and simply, recalling what the witnesses are going to tell them. We're going to call whatever Jones, his name is. He's a friend of Mr. Rankin. He was there that evening, and he's going to take this stand, and he's going to raise his hand, and he's going to tell the truth. And this is what he's going to tell you. He's going to tell you that man, Wallace Harper, came into the apartment that evening on June 29th or whatever the date. I don't think there's a date in there. Whatever the date is, without announcing himself, and then all the stuff he's going to tell, and there's some real dramatic stuff in there, right? Like I'll blow you away. That's important. That's a very important statement for the prosecution. And why is that? Because that's the only evidence of any premeditation, of intent. And that's the difference between first-degree murder and a lesser murder here, if he intended to kill him. And the statement from Jones is, I'll blow you away. Now, there's some statements from Rankin that the defense are certainly going to use. When he throws the ashtray, he says, tell any, if you live to see him again. So there's a threat back the other way with the ashtray. And that should come out from the defense. We should hear that from the defense opening statement. So don't shy away from those actual words that are going to be used. And there's actually some bad words in here. Somebody remind me of who said, so no, my cousin Vinny, everything that guy just said is. I would, maybe a little cousin Vinny, but not too much, okay? Certainly not too much cousin Vinny. I liked my cousin Vinny. I liked the dramatic presentation. More for closing than for opening, though. So if you're going to use a little cousin Vinny, save it for the closing when you can argue. You can be argumentative. You can be more dramatic. Let's try to keep the openings a lot cleaner without any argument and without any, probably, my cousin Vinny in the opening. But let me see. What was I saying about the opening? Essentially, you're just telling a story. A couple of things you want to add, and we haven't talked about them yet, the jury instructions. This is your opportunity to also inform the jury about what the law is in the case. So you can actually use your instructions. Don't overdo it, particularly for our purposes when we're doing less than 10 minutes. But you can talk about the elements that you have to prove, or the elements of self-defense, when once you've identified that that's the real issue, and then you can focus in on the elements of self-defense, which is, whether or not the defendant, the victim, well, the defendant was in fear of his life at the time that he used the deadly force. And we have jury instructions. That's what I was looking for. Here they are. We have jury instructions that are on the site for the class, and it has 4 things for self-defense. It says the defendant is not the aggressor. The defendant, under reasonable belief that in danger of great bodily harm or death, that there was no way open for the defendant to retreat. And that's an issue in this case, right? The door that was right behind him, that he turned to go out, and then when he gets hit in the head, he turns and he comes out his mouth. I see that as an issue in this case. In order to be entitled to self-defense, Harper has to be able to show that there was no way open for the defendant to retreat. And then finally, only recourse lay in repelling the attack by physical force. So those are important elements that the evidence in this case will either bear out or not bear out. I think it's important to address that at some point, even if it's ever so slightly in your opening, talking about the evidence. I skipped over the bad words. I was looking for them. Hey, I found that objection thing that I was looking for. They were both hiding right in front of me. What are the words in this? You tell any motherfucker or something like that. I mean, it's some bad words in this problem. If you live to see him again, and those are the words. I mean, they're not your words. They're the words of the victim and or the defendant in this case. And I encourage you to use them in your opening and more importantly in your closing. But some of you might hesitate and wonder, well, wow, how, this is a professional setting, a courtroom. How am I going to say those words, those horrible cuss words? And there's a number of ways that you can do it. You could say that, first of all, put the words on someone else. These aren't my words, ladies and gentlemen of the jury. These were the words of the victim that evening. And this is coming from, obviously, the defense attorney who wants to make the jury, not happy with the victim, and the victim was the aggressor. That's what you have to prove in self-defense. But these are not my words, ladies and gentlemen. These are the words of Mr. Rankin that evening. When he threw the ashtray at my client and said, somebody help me out since I don't have it in front of me. You read the thing. What was the specific thing that Rankin said when he said something like, take that, you MF, which is the other way to do it. Okay, in the book, it says actually the whole word, but you can use MF instead of. I think it takes away from it. It's not my recommendation, but if you're so uncomfortable, that might ease your comfort level a little bit and say, that he said, you MFer, and that'll be fine. Um, but also these aren't my words. These were the words of the victim, or the prosecutor. These were the words of the defendant, who I think had some choice words. Here, yeah, you tell him I will kill any MF that comes to collect his juice. Perfect. You're going to have to address that. I want you to say it. If you want to say it that way, MF, that's fine. But if you say it out the full way, then I want you to try to not make the jury judge you as somebody who's just dropping these F-bombs and cussing in court by really stressing that these aren't my words. These were the victim's words in this case.
Judge,
Yeah.
could you stop right there and say, and pardon me for my language, would that help like mitigate that a little bit? But it's important for
It does. That's the first
exactly
way that I left out. Apologize. I'll go ahead and apologize. I apologize for my language, but this is a real world event that happened, and these were the words that these people used, and this is what he said. You tell any motherfucker that that I will kill any motherfucker that comes to collect his juice. That has a lot more impact than when you say it and you substitute MF. Now, I will tell you, I mean, there are words that come up in court all the time that make me very uncomfortable. I just said the motherfucker, and I'm not as uncomfortable with that I would prefer saying MF. But there are some that I won't even repeat in here, and they come out. They're a main issue in the case. I had one not long ago where it was the N word, and that's how we referred to it, as the N word. No, well, one of the witnesses actually used the word, but the word was important because it had to do with the intent of the murder in that case, and something that had been said, calling each other names that included the N word. But I mean, that's a word that I don't want to hear. I don't want to see in the courtroom. It makes me very uncomfortable. And so when it was said most of the time, and it was mentioned in opening statement, it was mentioned by witnesses who testified, and it was referred to in closing because it was so important. It went to the elements of intent in this case. And for the most part, when it was referred to as the N word, and everybody knew what the word was without having to say it. So that is an option sometimes. The other one that I'm super uncomfortable with, and I prefer that they say the P word instead of saying the word in court. But again, you can, but be careful to sanitize yourself from just dropping that word. And technically, the F word should be just the same. I don't know why I've grown, I guess, more not as offended by that word as those other words. But just it's something I want you to be aware of. It's going to come up. These when you're dealing with criminal cases and murder cases, these words are out there. They're being thrown around, and they might be a part of the case, and you've got to figure out a way to deal with them. Putting them on somebody else, apologizing, shortening them, abbreviating are all ways to do that. But don't be afraid and leave it out. So those need to be in our opening statements in this case. Everything else about it, Denise, I really liked. I mean, overall, I thought it was really good. I don't have any other notes. What about, this is the point where I open it up to other class members. What did you think? Good, bad, indifferent? Nobody holds it against anybody. We're all ultimately we don't get as close on video here, but in the courtroom after 13 weeks, we're all close friends, and we learn to be able to criticize and critique each other. What does anybody else think about Denise's opening statement? Cindy, pretty great. Really liked the tone of her voice. Yeah, I agree with that. Great presentation. Just a great tone. Great presentation. I agree. Denise is inviting constructive criticism. Anybody see something that you think she could do better?
Yeah, it's fine. I had moot court practice earlier, so just let it rip.
I think you did well, Denise. So good job. I do have a question, Judge. Because I'm part of the mock trial board, and I did I actually did a trial like 2 years ago before COVID happened. Well, that wasn't 2 years ago, but a year ago. And weren't you supposed to establish venue?
Not in no in your trial you need to, but you don't have to establish
Not in your opening
opening
statement?
statement because the opening statement is not evidence.
Okay.
Yeah, so it's nothing. I mean, you may mention it, but it's not necessary. But
Okay.
once you start presenting your case as the prosecutor, you absolutely have to have somebody testify, and testimony is evidence that it occurred in that jurisdiction.
Okay. Thank you.
Yeah. No problem. And I'm glad you mentioned that because we'll be looking for that in direct examination from our prosecutors. And there's one other thing. So tell me if you remember the other thing that you have to establish. There's two check marks that I'm looking for as a judge when the prosecutor is presenting their case. It's venue and what? ID of the defendant. Absolutely, Joey. Yeah. And I mean that's the first thing that they're going to teach you as prosecutors. So it's not absolutely necessary that I teach you that here because when you go to a prosecutor's office, they're going to give you a checklist of things, and ID and venue are going to be number 1 and number 2 on that. And you or your trial partner at the table during the prosecution better make sure that those are checked off before you say what at the end, Joey. When is it too late? After you've said what?
I'm sorry, I didn't hear your question.
What is the important thing that you do that before you said at the end of your case? That you've make sure that you've established venue and ID before the point of no return. What's the point of no return?
When you rest?
That's right, when you rest. At some point, when you think you've done everything, and that's why I say you should have a checklist and you should go over and you should consult with your co-counsel and say, okay, I'm about to stand up and rest our case. You know, is there anything else? Did we forget anything? And when you go to that checklist, okay, we established venue. We asked the police officer whether it happened in Hillsborough County. We established ID because the victim pointed at him and identified an article of clothing that he was wearing in court, and we asked the court to acknowledge for the record that the witness had identified the defendant. So boom, boom, 1 and 2 is checked off. You may have had on your list that you were going to introduce a stipulation that was entered between the parties, and now is the stage when you realize, oh, we forgot to read the stipulation into evidence. So we want to do that before we rest, because once you rest, you can't go back and do any of that. And that's where you might get caught. Let's say you don't establish venue and you rest. Now the trial court turns to the defense, and the defense is going to stand up and make a motion for judgment of acquittal. And their basis, amongst others, but if that happened, that's a big deal, is going to be that you failed to establish venue. And I said I have a checklist too. Whenever that testimony comes in during a trial, I put a little check on the side of my notepad. I check and I put venue, and I put what witness. So just in case there's an argument later, the defense is arguing that they didn't establish it, I look at my notes and I say, well, I have here that Officer Jones satisfied venue, so that's denied. But if I don't have that, you probably didn't establish venue, and I'm going to have to grant the judgment of acquittal. And it has happened. It absolutely has happened. More often in misdemeanors with younger attorneys that are going to make mistakes like that. It's one of those mistakes that I think you'll only make once if you make it. I prefer that you not ever make it, but that you'll only make once in not establishing venue. But it's a very important part of the trial that you need to establish. But don't worry about saying it in opening. That's not to say that you don't have to. If it's part of your story, ladies and gentlemen, I'm going to tell you about an awful murder that happened right here in our own little town of Tampa, or whatever, because it did happen in. You wouldn't be in that courtroom if the jurisdiction wasn't in that courtroom. So it may very well be a part of your opening, part of your story. Anything else? Anyone else? Actually,
so I kind of thought, Denise might have said something that wasn't actually correct, 100%.
Okay,
let's
look at it.
So can I? Before I get to it, can I object? Can I say?
Oh, yeah.
During open statement?
You can object during opening, absolutely. In fact, one of the handouts separates the common objections to the different parts of the proceeding. And there's a whole section on opening statement in addition to argumentative, because you absolutely want to jump up and object if they're being argumentative. But tell me what it was, and then we'll try to figure out what the best objection for that is.
Well, so she said that he was court-martialed, when in fact the evidence only shows that he had court-martial problems, which could mean anything.
Yeah.
So I would say objection, he was not, in fact, the evidence doesn't show he was court-martialed.
Well, this is where you want to make a strategy decision, because one of my number one don'ts, the things, there's a lot of do's in opening statement, but one of the don'ts is don't make promises that you're not going to be able to prove, because you're going to eat it. The other side is going to come back and make you eat something that you say in opening that doesn't pan out exactly like you said it. So you've got to decide, do you want to make that objection then? And usually the court is going to say, I haven't seen the evidence yet. Okay? They're telling them what they think the evidence is going to be. I'm going to overrule the objection. If they're wrong, I have no doubt that you're going to point that out to the jury. So I'm not saying don't make the objection. You can, but most likely the court is going to say, I don't know what the evidence is. They can say whatever they want, with some reservation, they can say whatever they want. There are some ethical issues. But if they're stretching the truth a little bit, and whether that's intentional or accidentally, I'll bet that you're on the other side. You're the defense attorney. And where is that testimony going to come in? It's going to come from your defendant, right? So they don't have any other way of getting that evidence in. Not in this trial, because there's only 2 witnesses. The police officer is not going to be able to testify to that, and Jones isn't going to be able to testify to that. So they're going to get that out of cross-examination of your witness. And you can already from that predetermine that they've either misread or, are assuming something that's wrong. So they're going to ask that question. Isn't it true that you were court-martialed, Mr. Harper? And you've prepped Mr. Harper, hey, this is what they're going to ask you, and we know the facts and the truth. And what's Mr. Harper going to say? Absolutely not. There was a court-martial inquiry, but I was never court-martialed, if that's the facts. So now he's shut them down on cross-examination, and they're going to be like backpedaling and sputtering. Denise, if that's what you thought, and that's what you said in your opening, and that turns out to not be true, is that going to trip you up a little bit in your cross-examination of Harper?
Well, I did say that, because when I was reading through it, I went, oh, okay, well, that's a good, thing, but
more closely now, does it?
Mark, I'm glad you brought it up, because I wouldn't have realized it. So,
and we need to be careful about that. See, and I might have done the same thing as you. I might have read it and said, yeah, he was court-martialed, and then incorporate that in my opening statement, and I absolutely incorporate that in my cross-examination of him. Then come to find out that that's not exactly what it says, and there's a little wiggle room there. And now he's going to wiggle on cross-examination. And now Mark, in closing argument, is going to say, this is, one of the things, do you remember an opening statement when the prosecutor told you that he had been court-martialed? And there's been no evidence of that he was court-martialed. Because you're pointing out then to the jury, you're calling into question the credibility of the prosecution in this case. They made statements in opening that didn't prove to be true during the case. So I think that puts you in a really good position. Now, obviously, there's a line somewhere that's got to be drawn. I'm sure some of you are familiar with the Caylee Anthony trial. And that was Jose Baez, who, I don't know, some may think is a great attorney. I mean, he did get somebody off who I think was guilty of killing her daughter. He was very flamboyant and dramatic. But in his opening statement, he said some things that I think are completely unethical. And there's articles out there. It's been debated by people in the legal field ever since that case concluded. But he started talking about how she was sexually assaulted by her father and how she was impregnated by her brother. And obviously, those are things to get the jury to feel sorry for. They're outrageous accusations. And there was no evidence of it, and he never presented any evidence of it. So I think that there is a line that can be crossed. I don't remember in that case whether the state objected when Jose Baez said that in his opening. And if he did, what the judge did with it. But that's something where I would say that you should make an objection. So I think that whether he was court-martialed or not is something I would, if I knew the truth from the defense, would kind of lay in wait and do it the way that I previously suggested. But if there's some, the type of thing that once the jury hears that, there's no fixing it, that she was raped by her father and by her brother and was impregnated and had an abortion, because it was her brother who was the father of the child or whatever. There's these horrible things that Baez said in the opening statement. I think that's unethical. I think that's highly unethical. I think it's objectionable, and I would then bring the attorneys up and I would ask Mr. Baez to tell me exactly how he intends to prove that. What evidence are you going to introduce of that? And I mean, if he has an answer, either we're going to call, or we're going to call the brother, or I don't know. But it would be a very high bar for me to allow him to say that if there was an objection. So there is a line, I think. Let's see. Any other questions along those lines? What I'd like to do now is, I had forgotten, Joey told me before we started that she actually tried a case today, a real misdemeanor case in front of a jury. She picked a jury and did an opening statement and did direct examination of the police officer, I think. So Joey, and I asked her before class if she would mind sharing that experience with us, because she was telling me what a great feeling it was, which I agree, I know, and I remember when I was a law student and did my first trial. So Joey, you want to share that with us? Maybe share the facts and what you did and how you prepared?
Sure. I'll just start by saying that I actually on Mark's kind of last point with Denise, I used the defense in their opening statement had said that they anticipated that the police officer in the case had was going to testify that he was actually going over to what ended up to be the victim's house to arrest the victim. Like, they were saying that they had that he was going to testify that, or he was going to originally go arrest the victim in the case. And so when I called the police officer to testify on direct, I clarified that if he, did you have the intent to go over and arrest this other party, before your investigation had ended? And he said no. And so in my closing, I said, you heard that in the opening statement of the defense that they anticipated that the officer would testify that he was going to go over to arrest the ultimate victim in this case, and he didn't. So that was kind of like a sweet little moment for me. But
and Joey, those are the type of things that I recall, just looking for, that opportunity. And that's the way that I probably would have done it. Let me ask you this though: did it occur to you when he said it?
Yeah.
That raise a flag, and did you consider objecting when they said it in opening statement?
No, I didn't. I wanted to make sure that the police officer, because I had the probable cause affidavit, I had the police officer's report, and it didn't. And I also watched the body worn camera, and it didn't anywhere in there say that he was going over to the guy's where the guy was at to arrest him. He just wanted to get his version of events and his side of the story. So let me go. I need to rewind. I just wanted to kind of piggyback off that point before I told you guys about it. So it was a domestic violence battery case. I work in the misdemeanor division in the state attorney's office, and it was a DV trial. And what was kind of bad for us was that the defendant was a woman and the victim was the man. And the woman was the one that called the police initially and stated that her fiance was just got done choking her and he fled the scene. So that's kind of what the police went off of. when they got there. She was hysterical. She was drunk. Her friend was drunk. You should have seen their statements. Like, I saw the copy of the written statements. Like, it was a nightmare. Very not legible. But ultimately, they were fighting over the keys to a vehicle that the woman and her friend were out driving around in. It was owned by both the defendant and the male victim. And the male victim wanted to, they actually had a sober driver, which was the defendant's friend's child, like 16-year-old son was driving around as their DD. And they were, the guy went out and took the keys from the kid. And because his claim is that he didn't want to have this 16-year-old kid out driving around with a car that he insures with two drunk people. And so he took the keys for safety reasons. And then that's when the battery occurred, because she went and she grabbed them from him. And there was a scuffle, and he has lacerations, scratches. She has lacerations and scratches. But at the end of the day, the police officer found that he, that the primary aggressor in the situation was the woman. So he arrested the woman after he went and talked to the victim, the male victim in the case. So, yeah, that's the little backstory to that. And when I initially read it at first, I thought to myself that it was a mutual combat situation, like, you know, like they were both scuffling for something, and it was, you know, going in, I didn't think that we had a very strong case, but I think that we had, you know, going off of the jury instructions and what a battery is, which is any unwanted touch or strike against the will of the victim. Theoretically, you know, that first, since she was the one that initiated the contact against the victim, technically that met the elements for a battery, and that's what the state ran with.
Was the defense mutual? Was it mutual combat that they argued as a defense?
Yeah, the defense argued that it was self-defense. The defendant argued that she was choked, and there was no evidence of that. She had like some red marks on her chest, not around her throat, and so that was the only line of defense that she had, was her own word. Like, her friend didn't see it, nobody saw it, so it was his word against hers. She was also in the courtroom crying and bawling, and I seen the jurors over there looking at her, and so I was like, this isn't good. But yeah, so they said that it was self-defense, and you know, they presented the case where he was basically being a bully to her, and that they had a sober driver, and you know, that was their only way of leaving, and so he took away their only means of leaving, and so she wanted the keys, and that's why she proceeded to try and get the keys back. But she didn't attack him like the evidence showed she did. But again, the jury didn't buy it, because it ended up coming back not guilty. But I think we had a solid argument. It's just the evidence wasn't there.
It's not always about winning. That's what I want, these students to understand. It's not always about winning. And my last question to you is, how did it feel, though, even though you lost the case, how did it feel going through the process of arguing a real case to a jury?
Oh my God, it was amazing. Like, it was the most terrifying and exhilarating thing you could possibly imagine. Like, it was great. And the icing on the cake was the fact that the judge and the other attorneys had no idea this was my first jury trial. And that was I had written an opening statement for this class the day before. And then I realized I had to write an opening statement for an actual case the next day. And I'm like, oh my God.
Wow.
So yeah, it was great though. It was the best experience in the world.
Well, and that means you're a trial attorney, okay? And once you've got the taste of it, I have no doubt that that's the career in law that you will pursue as a trial attorney. And not everybody is that, and I don't expect everybody to be that. I've got friends I went to law school with, 30 years ago. They've never been in a courtroom since they graduated from law school. They're transactional attorneys, they're contract attorneys, and they never go to court. And they're perfectly happy. They wouldn't know how to find their way into a courtroom, and they love what they do. Not me. I've been a judge for 15 years, and I miss trying cases. I want to do a closing argument. I want to do an opening. I want to cross-examine a witness, and I terribly miss it. But that means you're a trial attorney, and that's going to go a long way. That's half the battle there. But thank you for that. I wish I could take credit, but we're so early in the class that I can't have you go back and tell that judge, that you're such a great lawyer because of your trial skills, professor. This is not true.
Well, you definitely helped in preparing me for this opening statement. So.
All right. Well, I'll take a little bit of the credit. I appreciate that. Well, I may want to call on you to do or see if you volunteer, but right now, Kiana has volunteered to be our next, and she's a defense, so that's absolutely perfect to follow Denise. Kiana, are you ready?
Ready or not, here I come.
All right, let's hear it.
Okay, so can everybody see and hear me okay? Because I know it's been some issues in the past.
No, we can see you and hear you perfectly.
So, ladies and gentlemen of the jury, the prosecution wants you to believe that my client is a premeditated murderer, somebody that actually literally thought through this process and committed a murder. But that's the furthest thing from the truth. I want everyone to know that my client is an upstanding man. He had a job and he followed his job description, which was to collect IOUs. So he was supposed to be deemed as the quote unquote victim, and he appeared to collect the debt. When he did so, he was approached with very, very aggressive response. Now, I ask that the jury takes a moment to think about the fact that if you owe money, it's not exciting. If we think about it for a moment, whether we owe bills monthly or something of that nature, it's not something that we desire to do, but we know that it's required. So as my client in this case went to go collect the debt on behalf of his boss, he was then experiencing an experience where he was enduring what it was like for someone to be aggressive against him. He did not go into the situation overly aggressive, disrespectful, or anything of that nature. He went to collect the debt on behalf of his boss. And when he did so, then he was presented with the opposite of what he desired to. And that resulted in him actually being injured. I asked the jury to consider what person with a reasonable mind would go to the hospital if in actuality they were going to have to get stitches, they were going to have to appear for something that they did that was an intentional crime. And that's not what happened here at all. My client is not a murderer. And the problem that we need to really address and arises throughout this entire case is the fact that they're trying to try my client for first-degree murder. But what requires first-degree murder is premeditation. And premeditation is something that you think through prior to an offense, something that you already have planned out in your mind. So how is it that my client went to the home of who's supposed to be deemed quote-unquote the victim, and the sole purpose of that was just to collect the debt on behalf of his boss, and that resulted in him being injured? He had to get stitches. Now, whether it's 10 or 13, regardless, if we say 10 as a minimum or 13 as a maximum, that's extreme. That's not something that a person should have to go through on their day-to-day job. I asked the jury to consider, what would you feel or what would you think if it was a situation where you were injured when you were just trying to do your job, what's described in your job? He was told that he was supposed to go collect the debt, and that's exactly what he did. And as a result, he ended up being injured, and he was not sure if he was shot. He was not sure if he was aggressively handled or whatever. But even if we want to say that in this situation, he acted unreasonably, it is reasonable. And the reason that I say that is because he turned around and he fired shots as a response to not knowing whether he was shot, whether he was struck, or whatever have you. But what I asked the jury to consider is this. So think about this. you're in a situation where you're trying to do what's within your job description. And if we all sit here and we think as a courtroom collectively, we have certain duties as a, as an employee. So if you do those things, whatever is required of you, that might require you to do X, Y, and Z, whether you agree with it or not. You may have a family to support, yourself, or both. So in that situation, when that happened, he was struck, and because he did not know what happened, he responded in self-defense. But what they're trying to say is first degree murder, is something that he should be charged with when that's premeditated. He didn't go over there with the intentions of actually harming a person. He went over there to collect the debt. So if we go further in depth with that, the problem is, should he really be deemed someone that's a murderer first degree or somebody that defended themselves? And my client was struck with an ashtray in his head, requiring whether it's 10 to 13 stitches, regardless. He went for a medical procedure for him to be treated. What person that's intentionally a murderer would go and do something like that? If you see in any type of movies going back in the day or anything that you hear of, typically a person that's intended to do and commit a murder, they don't go to a public facility seeking treatment. They would go to a bathroom. They would try to get themselves together to the best of their ability because they did something wrong. But that's not what the situation is with my client. I asked that the jury consider all of these things because in reality, it was self-defense. He presented himself. There's conflicting statements on whether or not the purposes of them meeting up and them having a conversation was aggressive on my client's end or AKA quote unquote the victim. But what we have to consider with all of that being said is that my client went over there to do his job, nothing more, nothing less. And because he appeared to do his job, he was then attacked. So he responded in self-defense as anybody should. And what I asked the jury to consider is if you were a person that didn't know whether you were shot, whether you were struck, what the opposing party did to you, how would you react? How would you feel? I believe with everything inside of me that my client is not a bad person. No, he wasn't pushing a clock from 9 to 5, but he was doing what was required of him by his boss for his own stability. So with those things being said, because he did so, that resulted in something he never foreseen happening. Premeditated is thought out way ahead of time. That's not what happened here. He went there to collect the debt. He could not collect the debt. He turned around to leave. He was struck with an ashtray, unsure of what he was struck with. He provided exhibits. If I need to provide that to the court, I'm asking for permission to do so. So when he was struck, he instantly thought he was in danger. And that gives a person a right to defend themselves. So that needs to be considered by the court of law. You're going to hear the prosecution tell you that my client is a heinous murderer, somebody violent, somebody evil. He fired all these shots into somebody's chest that's a victim. But isn't my client a victim? My client went there to do his job. That is it, and that is all. And in response, he was attacked. So I would ask the jury not only to take in consideration what we're here for today, these allegations, these claims, but to really consider what was the sole purpose of my client being there and how he responded and what he did and why. I think that it's very easy at first glance to be very judgmental of a person, to consider them angry, consider them violent, consider them to act unreasonably. But I ask you to consider, even if you're in your own home and you're not licensed to carry a gun, but you can have a gun in your own possession, would you pull if you were in fear of your life? If you were in fear that somebody is attacking you? If you endured pain, unreasonable pain for doing what you were called to do, and it resulted in violence and injury to yourself? You have that right. Second Amendment, you have that right. So at the end of the day, I ask that the jury considers all facts, aggravating and mitigating, to determine who my client is as a person, because he's not a bad person. He didn't go over there like, you know what, today I woke up and I decided I wanted to commit a murder. He decided that he was going to defend himself in a situation he didn't even foresee. So I ask that before, it goes any further, in opening statements, I'm going to address that he needs to have these allegations against him dropped because there was no intention of someone being killed or murdered that day. He went to collect a debt on behalf of his boss' request. Nothing less, nothing more. So I would ask the jury to consider all those things. I think it's very easy when you hear about a case at first glance to determine that the state is always right. But we have to be honest with ourselves. The state is always not always right, and neither are the people. We're both proven to have error at some point. And in this situation, as I'm speaking on behalf of my client as defense attorney, he is the person that if anyone was a victim, he was. He did what he had to do to protect himself. And I will provide any exhibits in XYZ to determine that, to show that that's exactly what happened here in this case. I asked the jury to address the whole entire court and the whole process and procedures with an open mind, because it's easy to be swayed by what allegations are, but don't decide that that's something you're going to do. Listen to the whole story in totality. And if even a portion of it makes you think that something is in question, you need to rule my client out. Because this was a self-defense case. This was not an aggressor. This was not somebody that went with the intention to be a bounty hunter or attack or be a murderer. I ask that those are things that are considered by the jury. Thank you for your time. I cannot hear you at all, Professor. I don't know if it's just me. I cannot hear you.
It was me. I was muted. Can you hear me now?
I can hear you now.
All right, I'm sorry about that. I was muted. Okay, lot of stuff here. Some really good stuff. Some stuff I really like. Some stuff that I appreciate you're giving me an opportunity to tell you that you can't do. And then also some stuff we really need to get our arms around it. It was big. It was too long. It was too much. So we need to narrow it, and we need to focus more, and we need to have a more cohesive, outline of it, okay? Because it bounced around a little bit. You never really told the story of the facts. You were kind of assuming stuff or jumping to stuff like getting hit with the ashtray without the jury. And you have to remember, we have to put this in the right frame, is the jury doesn't know anything about it. This is the first opportunity they're going to hear any of the facts. So that's why you really got to drop it down to the basics, and you got to spoon feed it to the jury of, this is what happened. You know, he went out that night. He went to the apartment. There was a lot of things, and you're very passionate. Let me tell you that, and I like that. And that's going to go a long way. That's going to be a benefit to you. I started by writing a note that towards the beginning, there was a little argumentative. Then I scratched that out, and I put it was too argumentative. Then by the end, it was so argumentative that I want to take back what I said about trying to get away with how much argumentative you can, because nobody objected, and I was waiting, and maybe I wasn't clear enough before. You can make objections during this. It's an open floor to objections. It gives us the opportunity, you to practice objections, and me the opportunity to rule on the objections. So I was waiting. I didn't want to do it. I didn't want to make the objection. I wanted to see how long it would go. But some of that really argumentative stuff is going to be great for closing argument. I want you to just, harness that and move it to your closing argument, and you will give a great closing argument. So that's one of the things. I like to keep an open mind. That's absolutely appropriate in opening, to let them know, and to let them know what the prosecution is going to try to prove. Now, you said you're going to hear from the prosecution. The way that this is going to happen, the prosecution is go first, so you can actually change that, and you can comment on what they said. You just heard the prosecutor tell you that my client was a murderer. Let me tell you why that's not the case. Let me tell you why what he did that evening was justified. While we agree that he fired those shots that evening that the prosecutor told you about, let me tell you why he had to fire those shots, to protect his own life so that he could go home that evening. Something along those lines. And I liked the setting it up in the beginning. He was just doing a job. He's a hardworking man. He's an upstanding citizen. Absolutely. That's good. You're setting. So it started out really good. and you speak from the heart. I don't think that you have memorized anything or that you were reading from. You just got the facts up here and you just gave it to us, matter of fact. And that's what led you to, you gave it to us in an argumentative where you were arguing your case. And this is not the time for that. This is the opening to just tell a story and tell us what the evidence is going to show. You didn't really talk about the witness. I never heard about Jones. I never heard about, the doctor or anything like that. So you got to try to bring that in. You talked a little bit about the law, but it was kind of a remote reference. I want you to talk more about the law. I want you to tell them that the court is going to instruct them, and this is what the law is. And what favors you is the self-defense. What you were talking about is premeditation, and you were bashing the premeditation. It's all right to do that. Say, the prosecutor, in order to prove the charges that they've made, they need to prove that this was premeditated. And in order to prove it was premeditated, they'll have to prove that it was something he planned and and all of that. That's good. But not too much time on that. Your focus, your theory of the case is self-defense. So you want to present the law on self-defense. What evidence is going to support that self-defense? And one of those things is, you made references to the stitches, but it wasn't clear how he got the stitches until the very end when you mentioned in the end, almost in passing, that he got hit in the head with the ashtray. So it was taken out of disjointed than just telling a story and putting it in a kind of like timeline from the beginning of that evening when he went to there, doing his job, tie all that in. He knocked on the door. He got no response. He knocked on the door again, no response. So he entered, and what was he met with? Who the fuck are you? So that language of Mr. Rankin is very important to you to throw that in, and that's not argumentative. Those are facts that you expect are going to come out because, your client is going to testify to that. I don't think Jones is going to testify to that, but your client is going to take the stand and say that when he entered, that's what Rankin said. Who the fuck are you? Or what the fuck do you want? Something along those lines. So go back and look at those facts and work them in, and do it in a story type style. Now, you also kept calling him my client. That desensitizes him. It's better to say Mr. Rankin than my client because your client has a name, and if you're just saying my client, it kind of desensitizes. It removes, the personal, which you, as so emotional as you are, that takes away from it. Say my client, work in poor Mr. Rankin. And I'm not saying. I'm saying poor Mr. Rankin in a matter of sense, not in saying poor Mr. Rankin. Don't say poor Mr. Rankin, but Mr. Rankin. Let's see. So I have a note. Talk more about the evidence. Talk more about the evidence. Tell more of the story. I like the way you were speaking from the heart. Talk more about the law and the burden. One of the things you left out is the very high burden that the state has. It's the highest burden in the law. They must prove their case beyond and to the exclusion of all reasonable doubt. No defense attorney gives up that opportunity to tell the jury early on how high the burden is of the state. So let them know up front that it's a very high burden of the state. You might want to, and most in this class, most don't. This is something that usually comes later as you develop. But the presumption of innocence, that's certainly something you can talk about. He comes to this courtroom with a cloak of innocence. He is presumed innocent unless they prove what the law says they have to prove, and they have to prove it beyond and to the exclusion of all reasonable doubt. So that gives you the opportunity to talk about the law, the high burden, and stuff like that. Now, another thing, a lot of students do. I have some attorneys do it. Usually when attorneys do it, I call them up to the bench and I tell them, nobody cares what you believe. You said, I believe, or I think. Drop that completely, that. If you want to say the evidence will show, then follow it by whatever it was that you thought, then that's perfectly fine. The evidence will show, but never say, I think. It's improper for an attorney to share their personal feelings, beliefs, or anything like that. So I think, I believe has got to go. Now, here's the big thing, and it's okay. Don't worry about it. This is the time to do it. But you caused a mistrial. Let me see if anybody knows where you caused the mistrial. And I agree with there's a quote there that somebody said, a chat, they say they love your passion. I do too. I really do. We're going to be able to harness that and make you a really good trial attorney. I have no doubt. We just need to put that passion in the right spots, and we need to give a little more structure to your opening. But where is the mistrial? Anybody see anything that she did that you've learned in evidence? And you may not have addressed this yet. We really call it the golden rule because it's so important, and it cannot be done. It is an absolute mistrial to do.
You can't. You cannot.
So are you? Did you know? Or I haven't said it yet. Do you know what it is?
You can't ask the jury to put themselves in the shoes of the defendant.
Absolutely, that is the golden rule. You cannot ask the jury to put of any party, the victim either. So you can't. You have to absolutely avoid putting the jury in the shoes of either party in the case. And you did a number of times. What would you think? Where would you? What if it was you? All terrible golden rule violations that would cause a mistrial. So just don't ever do that. Now, you might ask, well, is there a way that I can? What would the reasonable person do? Might be a way to come back and get around it. But what would you do? Particularly if it's like in this case, the instructions even refer to reasonableness of a reasonable belief. Would a reasonable person believe that they had to use, and actually, you want to be even more affirmative, a reasonable person would believe if they had just got hit in the ashtray. And actually, I'm arguing now, and I'm realizing that I would have to put that in my closing argument, not in my opening statement. I would simply lay out the facts. I would tell them what you're going to hear, what you're going to see in this case is that when Mr. Harper went there to do his job, he was met with force. He was met with such force that it caused him to bleed. In fact, Mr. Rankin threw an ashtray at Mr. Harper and hit him in the back of the head that caused a bleeding gash wound to his head that required 13 or 15 stitches. I wouldn't make too much about the difference because in the end it doesn't matter. But the other side, there might be some testimony about the discrepancy in the 13 versus 15. In my opinion, that's somewhat of a red herring in this case that I wouldn't spend too much time worrying about or making a big issue of. It might be an area where the prosecution might want to try to pick away at the credibility of the doctor by saying, in two different reports, she didn't even. So I would leave that, alone from the defense side. But let's see. The big thing was the golden rule violation, and it would be a mistrial. And in fact, it's one where I think even if there was an objection, I would have an obligation to declare a mistrial in that. The other big thing was just the argumentative. But again, wait.
Professor, I just want to thank you so that I can get better. Like, that's the point of all of this. So I'm taking notes about the things that I could do better in the future because I want to make sure that I progress.
Okay.
I really do.
Well, and we're gonna work on it. Like I said, you've got a really good presentation in the emotion and speaking from the heart and the ability not to rely on notes. We just need to separate and kind of put the argumentative stuff at the end and the more basic storytelling in the beginning, and then not do some of these absolute no-nos like putting the jury in the shoes of the parties, and you're going to do absolutely fine. I have no doubt. You have a lot of potential.
See, and I was so scared because exactly what you said, there was issues with what amount of stitches were required. And, they had very conflicting arguments. So my biggest fear going into the opening statement is here I am giving, the defendant my client or Mr. Rankins, as you say, his version of the story as opposed to the story you hear at first glance. And I think that's already impacting the jury. So I was very like panicky about that because I'm like, I didn't know how much to incorporate from these differing stories or not, because
Absolutely. No, absolutely. I see that. And that's why it was too long. And that's why I said that you got to focus. We got to cut this down. And they throw a lot of facts in you. And this case is shorter than the other. The other cases will throw even more, but we still have the same amount of time. You still got to present this case in a 2-hour trial where you have no more than 10 minutes for anything. So you're not going to be able to get into everything. And when they throw things at you like the stitches, I would ask you, your theory in this case is self-defense, that it was justified, that he had to do it in response to the threat that was coming towards him, the ashtray, and he didn't know what was next. Really, how important to your theory is the difference between 13 or 15 stitches? It's inconsequential to that he got hit in the back of the head with an ashtray that caused a gash that needed stitches. Whether it was 3, 5, 15, or 20 doesn't matter. And I don't mind you if you find that you have the time to briefly mention it, but certainly don't make it anywhere near a focus of your case because it's so inconsequential to your theory of the case. And that's not the only thing you got to ask through it, because you're going to have to eliminate stuff. Stuff is going to hit the chopping room floor. Facts in this case, because we would be here. We would do a whole day trial if we talked about everything. Your opening statement would be 30 minutes. Your closing argument would be an hour and a half, and we don't have time for that. So we've got to eliminate focus and just cut to the chase. But that's what we're working on. That's the purpose of this. That gave us an opportunity to realize that in your opening. Good job, Phil.
So much, Professor. I truly believe by the time I complete the class, I'll be a better at presenting. Regardless of what side I'm on.
I promise you that. That's the beautiful thing about watching my students through the progress. I'm so proud of you all. You all are already great, but I'm so proud of you all when I watch you all at the end. The level of progression is just fantastic. But it comes from hard work. And it's not just the 3 hours that we spend or 2 hours and 50 minutes that we spend each week. You've got to do hard work outside of the classroom, and some of that is watching, those mock trials, watching real trials. That's why I require you to do those 6 hours. And it's not always stuff that you're going to see that you say, oh, I want to be like that. You're going to see stuff you say, oh, I don't want to be like that. I don't like that. I don't like the way that person does whatever. And you incorporate that into your own. You've got to develop your own style. Most importantly, you've got to be comfortable with your style. I don't want you to try to be like someone else. I want you to be yourself. I want you to be comfortable. Because once you're comfortable, all the other stuff will come. If you're nervous, if you feel out of place, or anything like that, then you're going to be worried. You're going to forget stuff, which you don't have that problem, okay? You did it without any notes based on your knowledge of the case, and you talked to the jury. And that's what I want you to do. So that was very good.
I will just try to get a little better each week. So thank you again.
You're welcome. All right, who's next? We have any other volunteers?
I have a quick question.
Sure, Mark.
So if I don't want to see my doctor impeached and I never bring up stitches in my opening or direct, they can't bring them up. Is that true?
Okay, that's a good question. Let me just, you as the defense call the doctor and you don't ask the doctor how many stitches, and then on cross, the prosecutor gets up and wants to ask about stitches that you didn't ask about on direct. I would say, yes, that's beyond the scope of direct, and you can object to it. Now, and that'll work. In these trials, that will work. Well, I can't speak for the other judges. Different judges have, it's a, pretty much fluid moving target and there's some discretion there for the judge. And that's why I'm ultimately explaining why in the real world it wouldn't work. But for purposes of this, I tell my other judges, and in judging my cases, we try to be pretty, by the book on Beyond the Scope. So yes, if you didn't talk about it in direct, they should be able to talk about it on cross. However, if you talk in direct with your doctor about the wound, the other side might argue, well, you know, that's part and parcel to. They talked about the wound. It's not beyond the scope to talk about how many stitches the wound had. And some judges might say, yeah, I'm going to allow you to do that. So it's a good try. We didn't talk about how many stitches, therefore they can't talk about how many stitches, and you might get a sustained beyond the scope objection to that. You might have another judge who says it's all the same, part and parcel. You had the doctor talk about the wound, how many stitches were in the wound is just like that. That's too crafty to try to eliminate that. If you don't talk about the wound at all, then absolutely there's no argument that can be made that how many stitches the wound got is still within the scope. But here's what happens in the real world. Well, actually, I take that back. From the prosecution's perspective, technically they could if they wanted to put on a rebuttal case, but nobody's going to let them put on a rebuttal case on this. Where I see it come up all the time is the prosecution's witness. The prosecutor limits the scope, doesn't ask the detective absolutely everything. The defense then gets up and wants to ask them about something the prosecutor didn't ask about. And the prosecutor says, objection beyond the scope. I call them up to the bench. And a lot of times I find myself saying, they're absolutely right. You're absolutely right, Mr. Prosecutor. It is beyond the scope. And technically, I should not let them ask about it. However, they're going to have the opportunity in their case in chief to call this detective back to the stand tomorrow or the next day or this afternoon, depending on when we think the state is going to rest. They can call them as their first witness, their last witness, whatever, and they can get into this because now it's their witness. The only difference is that when they call them as their witness, they can't ask leading questions, which they are normally able to ask on cross-examination. So what I'm going to do is I'm going to exercise my discretion to allow them to get into it now rather than have the detective wait or come back. But I'm not going to allow them to ask leading questions on this material that is beyond the scope. Then, when you have the opportunity to redirect, where you normally can't ask leading questions on this new material, I'll allow you the opportunity to ask leading questions, just like it would be an hour from now, a day from now, whenever they got the ability to call. So whenever I do that, I'm telling them, I'm not asking them, I'm telling them this is how I'm going to do it, because they absolutely could recall that witness and get into it. But this is a little different. Technically, you wouldn't provide me the opportunity to rule that way, where it's the defense who's presenting, because the state won't have the opportunity to recall them as a witness. So I think it's a good objection. You should make it. Yep. All right. Where were we? Volunteers. Anyone volunteering?
I can go, Professor.
All right, Joey. Now I'll give you the opportunity. If you want to give your opening statement that you gave in your case today, I would love to see that.
I don't know if I have both. So,
Volunteer's choice. You're volunteering, so you get to do either one.
Okay. Let me see if I can. I think I changed it around a little bit, but I should have a copy of it. Hold on. Let me see.
We've already heard. We're bored with Harper now. We know all about the ashtray and all that.
Oh, now you're egging me on to do the other one. Okay, I see how it is. Your true feelings do come out in this. All right.
It won't affect your grade.
All right, hold on. Let me bring it up because I worked on it at home and then I changed it a little bit in the morning after
It should be in your mind. You gave it today. It doesn't have to be.
It wasn't today. It was yesterday. And yeah, no, I didn't memorize it because I only had like a whole day of I had trial prep on Tuesday with the attorney, and
How long did it last? How long was the opening when you gave it?
Oh, it wasn't very long at all. It's not, because we didn't have a whole lot of evidence. And yeah, so It wasn't very long. It was a couple of paragraphs.
While you're looking for it, I'm going to share a saying that goes back to law school that I think is appropriate. And we more said it for closing argument, but there's three closing arguments that you give. There's the closing argument that you plan to give, there's the closing argument that you actually give, and there's the closing argument that you tell your friends that you gave. And none of those three are the same. So this is your opportunity, rather than going back. Remember, the three are the one you put in to give, the one you actually gave, and the one you tell everybody you gave. So here's your opportunity to just tell us the opening that you gave, regardless of whether it was the actual words or what you planned. You're familiar enough with the facts. You lived the case. You researched the case.
Okay. I found it, so you don't get to get the preemptive version. So, All right. So again, I'm going to read it. So just so that's out there, because I didn't memorize it because I had a whole like half a minute.
Well, stop for a minute. When you delivered it in the real trial, did you read it?
I did as best as I could not to read it, but yeah.
Oh, all right. Well, we need a lot of work on you. Go ahead and read it.
Okay. Listen. We have 600 cases at the state attorney's office. And I brought that fact up because I'm like, I'm not going to be able to memorize it. And the attorney's like, look, and he said exactly that. He's like, we have 600 cases on our docket. And if we go to trial, especially in DV cases, you're not going to be able to memorize it. So you're going to read. So that's what he said. And so I stuck with what he said.
But you're smarter than that. You could have written it, and then you could have went back and written down on a page 10 words that would have triggered that entire written, and that's the only thing you needed in front of you was those 10 words. And when you looked at each one of those words, it gave you 50 or 100 words of your knowledge to say. So that's what I want to teach you to do, to show that attorney who's telling you to write it out and read it that, yeah, that's fine. Write it out the first time, but then boil it down to a few words that you can have in front of you, and you can look down, and then you can look up and talk about each one of those words.
Yeah, no, and I definitely wanted to do that. I didn't. The nerves were there. And I'm actually really glad I kind of didn't, because I was literally, my voice was shaking. And he said that he couldn't see or couldn't tell that, but
That's understandable. That's understandable. I was like that too. I even still sometimes, when there's cameras in my courtroom and I know that I'm going to have to pronounce, and I'm going to talk, I'm not just going to say, I sentenced you to death. I'm going to talk about, the impact that this had and the victims and all of that. My heart starts pounding before I start to talk. I still get nervous. But then once I start, I find after a few words, I settle down and I calm down. So that's human nature, and there's nothing wrong with that. And I see that in this class with all of my students a lot of times. When they start out, they're opening, they're closing, whatever it is, you can see a little bit of unsettled nervousness in the beginning. But they forget all that. Once you get into, a few moments of it, that all goes away. It all drains away, and, if you're prepared. And I'm sure that that's ultimately what happened with you. But I keep delaying it, and we're never going to hear it. So let's.
Okay. All right. Ladies and gentlemen, the evidence will show that in the early morning hours of May 24th, 2020, the victim, Sean Treckenbross, was in his home when his former girlfriend, the defendant, and her friend entered the home unexpectedly and caused a lot of commotion. Admittedly, the evidence will show that the defendant admitted that her and her friend had been drinking earlier in the night and was not expected to be home at all. When Mr. Treckenbross realized that they had been drinking, he went out to his and the defendant's car that they owned together and took the keys because they did not want them to. He did not want them to drive as they had been drinking. When Mr. Treckenbross came back inside the home, he was attacked by both the defendant and her friend because they wanted the keys back, and Mr. Treckenbross refused. The evidence will show that the defendant has already admitted that she tried to take away the keys from Mr. Treckenbross. She was the one who initiated this contact. The evidence will show that the defendant does have some injuries. She has a cut on her finger and some redness around her chest. The defendant injuries from Mr. Schreckengrass due to him having to push the defendant off of him as he was attacked by two intoxicated people. The evidence will show that the altercation that occurred caused the victim, Mr. Schreckengrass, to have scrapes and lacerations. He has long scratches on his arm, another one on the side of his body leading up his back, and a laceration on his forehead. The evidence will show that once Mr. Schreckengrass was finally able to free himself, that he removed himself from the situation and went to his brother's home. The state is confident that after you've heard all the testimony today, that you'll come to the only reasonable conclusion, namely that the defendant, Ms. Povia, is guilty of battery. And that was it.
Okay, and it's a perfect length. You know, it's shortened to the point, which is perfect for. I mean, that was like a half-day trial, right?
Yeah.
So that's as close to a real-world, length of trial as that we're going to be able to do here. But we're doing a murder trial in 2 hours, which is completely unheard of. So that's why here we have to really manipulate our evidence and what we put in our presentation. But it was a well written and well delivered. Okay, even though you read it, you were making eye contact, and it didn't take away from the good content in there. You used the evidence will show. You used it a couple of times. I like that. I don't like too much of it. Yours, I counted at least 3 times. And the only time I made a point of it was at the end, where you said the evidence will show once Mr. Scheckenberger was able to free himself, he went to his brothers, whatever. You could just say without saying. There's no need to put in front of that. You can say once Mr. Scheckenberger, you can and get away from your notes, get away from and look the jury in the eye, because that's almost your finality. Just look them in the eye and say, ladies and gentlemen, once Mr. Scheckenberger was able to free himself, he went to his brothers, and just make the statement. Make that bold statement without putting in front of it, the evidence will show, the evidence will show. I'm not saying you did it as bad as I see it done sometimes, where everything is, the evidence will show, the evidence will show. But it's really not necessary. I don't mind it a couple of times, but try not to do it as much. What I did is I wrote down a couple of words that I thought were the main key points that would be the words that I would have on a sheet of paper, and it would be drinking, admission, keys, injuries, scrapes and lacerations, and then I stopped. You had a couple of other things, but with going back and just looking at those words, I think that you would be able to recall that entire opening statement to the jury without reading anything.
Yeah. No, I feel like I could too. I just, like I said, like this was my first ever experience in a trial at all. Like I've been in hearings and I've argued motions and all that stuff, but like this first, real world situation of actually being able to practice law, it was terrifying. And I was so like nervous because I have a judge, I have, actual jurors in front of me. And like, I knew that if I did not have like something written down in front of me, that I would not be able to focus my mind on what I needed to focus it on. So that's why I tried not to read it like I did. But there was no way I was confident in myself enough to not have those things written down in case like I did decide, okay, well, maybe I need to say a couple of things here that I didn't have written down, and then I'm going to get lost. And then I need to be able to like, go back to the.
I hear you, and I accept that. I'm not going to argue with you. I accept that as your first time, and you get those jitters out your first time, and okay, acceptable. And when you listen to, like, we're gonna maybe next week when we're talking about cross-examination, we're gonna listen to a little video, and he talks about how it takes 20 or 30 trials before you completely are so comfortable that you lose all those jitters. I don't think it should take. I think that's too generous to say 20 or 30 trials. But certainly your first one, you're allowed that. So that's not a problem. I understand. Just as long as though, but it's a crutch. Well, I want you to realize it's a crutch, and if it's there, you're gonna lean on it. And what I hate about this virtual scenario is that I don't have the ability of what I used to do in the classroom. See, we're in the classroom, we were there, and everybody prepared, and then they knew it was in their head, and they also had it written down. And they got up there in the podium, and they started to do it, and they got nervous, and then they got stuck to their notes, and they were reading it. And what would I do? I would get up, and I would go, and I would take the pad away from them, and I would tell them to continue. And every time, every one of them did phenomenal, okay, without the notes, because it was there. What was on those notes came from where? Came from here. You put it on those notes, so you don't need those notes. So I really, really dislike that crutch that's there, because if it's there, you're going to lean on it. And I don't have the ability in this virtual classroom to walk up and take your notes away. I really miss that. Not as much as I miss doing closing arguments as a lawyer, but that's the thing I miss most as a professor, is being able to get up and snatch your notes away from you when you're doing your opening and your closing in this class. It was a good job.
That would be a battery, Your Honor.
If they're on the podium, though, it's not. If they're in your hands, yes, technically it would be, and I would say charge me. But it was really good. I mean, you're way ahead of the game. You've actually done a real trial, so that's just incredible.
I appreciate your constructive criticism, and I definitely want to have that goal to, not have to have everything written down. But like I said, it was.
You'll get there. You'll get there. And that's all it is constructive criticism. I promise you that by the end of this class, you won't need it. You will be confident enough that you will just stand up and do it.
I will take your word for that. Thank you.
All right. You are very welcome.
Professor, may I ask a question before we go any further?
Yes.
How harshly are we being graded on this first time?
You're not being graded at all. This has nothing to do with your grade.
Listen, don't make my day. Oh, damn.
Listen to me, because you asked, and I don't remember if you were here when I went over the syllabus. Your grade in this class is based largely on the 3 trials that you do at the end. 25 points for each of them. That's 75% of your grade is those. The rest comes from the trial notebook, only one notebook that you'll turn in on the last trial, and the Cali exercises. That's your whole grade. Anything we do between now and then absolutely has no impact on your grade. Next.
Thank you.
You're welcome. Okay, now that's fine. That's mine. I thought I saw a hand go. I thought someone was raising their hand. It was my hand. I found my objections, so I want to go back to that because I felt like I was doing miserably, completely unprepared. That was an example at the beginning of this class of unpreparation because I lost my notes and I was going over the objections, just absolutely terrible. Let's see. Here. While discussing the bombing campaign in the Pacific, the lawyer on cross-examination asked General Smith, "Your wife and you have been having some trouble in your marriage, hadn't you? What's the objection there?"
It was leading.
Well, it's cross-examination.
Okay, I missed that part.
Yeah, no, it says ask on cross-examination, so it should be leading. That's good though. That's all right. Don't worry about that mistake. But the issue here is whether the bombing campaign should have been carried out. I mean, I don't know the exact issue. These are pulled, and I don't have the exact what the trial was. But the objection here is relevance. I mean, what's the relevance of when discussing the bombing campaign in the Pacific, whether the general was having marital trouble or not? So the objection is relevance, and that's where we go back to 401, and it has to be a pertinent issue in the case in order for it to be relevant. The next one is the lawyer on direct questioning asked, "What did General Arnold tell you?" Ask the witness, "What did General Arnold tell you?" And this should send a flag up, and absolutely every one of you, all 12 of you in this class, should say hearsay objection. Absolutely. It's asking for an out-of-court statement, and then we would have to ferret through it. the response might be, but it's not being offered for the truth of the matter asserted. And let me tell you, how in trial, I don't know what the witness is going to say. So let's take this just like that and say that we're in a courtroom and there's a witness on a witness stand and there's an attorney at a podium and the attorney asks the witness, what did General Arnold tell you to do? Now, I don't know what's going to come out of that witness's mouth. I don't know what the general told him to do. So the other side objects, hearsay, because what do we know at that point? We know that he's about to testify about an out-of-court statement, and it is absolutely appropriate. I encourage you to make that objection at that point. Now, unless you know what he's going to say, and you know that it's not being offered for the truth of the matter asserted. Because if that's the case, then no, that's a bad objection. Don't make it. But when the objection is made, I, as the judge, need more information to know how to rule on it. That is not one of those where I can sit back with my arms crossed on the bench and say overruled or sustained, because I need to know what the answer is to determine whether it's hearsay or not, whether it's being offered for the truth of the matter asserted. So that is where I'm going to ask you to approach, and I'm going to ask the person who asked the question, what is the witness going to say? And then they're going to lay it out there. And then I'm going to turn to the person who made the objection, and I'm going to ask, are you asserting that that's being offered to prove the truth of the matter asserted? And I have to use, because I set this up like this, I have to use this example. And I won't use all of the nasty, dirty language of it, but it's a situation in a capital sex battery case where the victim was under 9 years old and had been sexually assaulted by her mother's boyfriend. And she is on the stand, and she is a great witness. I mean, just you just fall in love with this little girl. She's just an incredible witness, a very strong and very tough. I told you other parts. I told you where the grandmother of the defendant, or the mother of the defendant, called her a liar because when she was in her pool, she said that she could swim across the pool, and she actually swam across the short end, and so the grandmother said she was a liar. But in this particular cause, the defense attorney, who's a very good, he mainly does sex battery cases, almost all he does, public defender, but very good attorney. And he asked the little girl, how did you report that the defendant, I'll think of his name in a moment because it was kind of a silly name, Jack Frost. His first name was not actually Jack, but his last name was Frost. And in the beginning of the trial, I said, Joe Frost or Jack, whatever. And he said, I prefer to be called Jack Frost. Okay, buddy, we're going to call you Jack Frost the rest of the trial. So anyway, that's a side issue. The defense attorney asked the little girl, how did you report that Mr. Frost was doing these things to you? Or who did you tell? Who did you tell? And she says, well, I guess I told everybody on the playground. That was her answer. And that's not calling for hearsay, right? Who did you tell? Don't make the hearsay objection because they're not looking for the content of it. The very next question was, what did you tell everybody on the playground? Now, that's where the flag goes up, because the answer to that would be the content of the out-of-court statement. So the prosecution jumps up and objects. Hearsay, objection, hearsay. And so I say, all right, well, I got to find out what the content is to determine whether it's hearsay. Come on down. So I asked the prosecutor, Miss Prosecutor, what is she going to say in response to that question? And she says, well, based on prior testimony, deposition testimony, we believe that she is going to say that she's saying, I know mommy's secret. I know mommy's secret. She likes sucking, blah, 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 bad words. Jack's, blah, 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 whatever. So I then asked, I said, well, so now we have the content of it. We have the matter asserted is what she's saying, that she knows mommy's secret and that mommy likes whatever. I asked the prosecutor. Usually I would go to the defense and I would say, are you offering it to prove the truth of the matter asserted? What is the matter asserted? That mommy likes doing whatever. I skipped the defense attorney because it was clear to me that it wasn't being offered to prove the truth of the matter asserted. So I asked the prosecutor, I said, is it your position that they're offering that testimony, eliciting that testimony to prove the matter asserted, which is what mommy likes? And she said, I withdraw the objection. Because it became very clear at that point that that was one of those out-of-court statements that wasn't being offered to prove the truth of the matter asserted. Now, in hindsight, looking back, I don't know what that was being offered to prove, but it clearly wasn't being offered to prove whether mommy liked doing something to Jack or not. That wasn't an issue in the trial whatsoever. So maybe a more appropriate objection would have been what? What could the prosecutor have then said? I'm sorry, I withdraw the hearsay objection because it's not being offered the truth of the matter asserted. However, I would like to raise a what objection? Absolutely, Victoria. Relevance. What's the relevance of what the girl said about Jack or mommy's secret? Not relevant at all. And I would have sustained that. In hindsight, looking back, had the prosecutor subsequently made a relevance objection, I would have given the defense an opportunity to explain to me, but I can't imagine an explanation to make that relevant. But the hearsay objection was very easily, in fact, the prosecutor realized it's not being offered truth of the matter asserted, therefore it doesn't meet the definition, it's not hearsay. I'm sorry, I withdraw my objection. Let the little girl answer. And then the little girl answered by actually singing it the same way she sang it on the playground. But again, I mean, it just, in my mind, she was a very credible witness. It added to the credibility of the witness. I think it hurt, or at least I would have thought it hurt the defense. Unfortunately, in the end, the jury did not find him guilty of the actual sexual battery. They found him guilty of a separate, charge with multiple different offenses, but a separate attempted sexual battery. He's still spending the rest of his life in prison. But anyway, I apologize for the content of that, but it is a perfect example of crystal clear not being offered for the truth of the matter asserted, and therefore not hearsay, even though it was an out-of-court statement. All right. Let me see. Let's try a couple other just objections that I think are. Here's an example of argumentative that I was trying to make up earlier, but here it is. You were trying to terrorize the Japanese population into surrender, weren't you, General LeMay? Argumentative. And that rule, and I apologize, let me go back. I gave you the rule on relevance. That was 401. The rule on hearsay is 803. And then we talked about before the exceptions to hearsay. This one, argumentative, is Federal Rule of Evidence 611A. Just briefly, what does 611A say? 611A says, the title of 611 is Mode and Order of Examination, Witness, and Presentation of Evidence. A says, control by the court. Purpose, the court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to, 1, make those procedures effective for determining the truth, 2, avoid wasting time, and 3, protect witnesses from harassment or undue embarrassment. So that's where the argumentative objection is based on, 611A. But I like to use 611A for that other one, avoid wasting time. So I have that highlighted on my cheat sheet that I have up on the bench with me. And when I think the attorneys are asking a whole bunch of unnecessary questions and I get the opportunity to get them up to the bench, it might be because there was an exception I asked them to approach. I usually tell them, while you're up here, I want to remind you of Rule 611A and subsection 2B of that. It says that I can prevent you from wasting time. You're wasting time. Get to the point. Usually just a warning that I will throw out there, and I have in the rules support for that I shall control the mode and presentation of evidence, and I should do it in a manner that avoids wasting time. And because I'm cranky and old now, and because I've done this so many times, I didn't used to be like that. I used to just sit back, sit on my hands and not assert myself in a trial. But now that I've done so many high-profile, important trials, and I've done so many trials, and as I said, I'm very old, I'm very cranky. Most trials don't go by that I don't have a chance. That's one of the jabs that I'll throw at the attorneys, you know, and I have the support. It's not like I'm just, you know, a rogue judge who's out there saying that I've self-anointed myself to not waste time. The rules say that I have that obligation, and I'm asserting it. Stop asking stupid questions. Stop asking irrelevant questions. Get to the damn point. What's the point of this witness? Just get to that. We don't need to know about the history of how the word was invented. We need to know that this witness tested the DNA and it matched the defendant. So let's get there. I'm sorry. I'll get off my soapbox. Let's try another one. I love this one. This one comes up, and you'll see opportunities for this one. The lawyer on direct examination asked the witness, General LeMay, what was going through that bombing commander's mind?
Speculation.
Absolutely, speculation. And where is that? That's Rule 602 of the Federal Rules of Evidence, which is titled Personal Knowledge. And it says the witness may not testify unless personal knowledge is shown. How can this general know what was going through someone else's head? Maybe that person told them. And if the basis of the knowledge is hearsay, well then, then you've got that objection on top of it. But that's not personal knowledge anyway. What someone told them, it then involves potential hearsay objection. But you can't guess, you can't speculate. A very, I don't know if it's very famous, but a case that came up on this because a lot of times there's debate over whether it's speculation or not. And I've taken a position that what this person thought is not hearsay. What did you think when you saw that? Inevitably, somebody's going to object to that as speculation. And there's case law out there that says that they can testify as to what they thought. If that was the impression that they had at the time, that's not speculation. That's once removed from what someone else thought. So, like in our case, let's take this to our facts in the Harper case. What if the defense attorney asked Mr. Jones on cross-examination whether Mr. Rankin was scared? Calls for speculation. There's no way that Jones can testify as to whether Rankin was scared. Now, a good question though of Jones, and I don't know, maybe this is actually better coming from the prosecutor to establish the fear of the defendant. So the defense attorney, I scratch that. The defense attorney wouldn't ask that. The prosecutor might ask this. But still, prosecutor can't ask Jones whether Rankin was scared. But how do you not get around that, but how do you almost accomplish the same thing since Jones was in the same situation as Rankin?
Wouldn't it be okay for him to testify that it was his impression, like a present sense impression that he was.
Well, that's a conclusion. If he concludes, and the way I always handle that objection is, I say, look, you can get the witness to testify to the things that led him to that conclusion, but not that conclusion. What did you see? I saw him jump. What else did you see? He was crying. He was screaming. Okay, that's what led him to the conclusion that he would have said he was scared. So he can't say he was scared, but he can lay out the facts that he saw, that he has personal knowledge of, that led him to that conclusion. So you can take it right up to the conclusion and stop. What did you see? I saw him jump. I saw him crying. So I allowed that. But, well, I already said that. The case law says, if it was your feeling, you can testify how you were feeling. There is some other case law, though. What would you have done if the situation was different? And does anybody think that that's speculation? For me to ask, Joey, you said you think it's speculation to ask what someone would have done had the situation been different. And you're right. Okay, there is the Ajax case, and it's a federal case. I don't have the site for you. You don't need it. Just trust me. That in the Ajax case, it was a speculation objection. The mother had sued Ajax, which was a company that made it's still out there. It was this very
Like Comet, right?
Comet is the exact same thing, but it's you know, to clean the sink with, but it's very corrosive. That's the word I was looking for. A very corrosive cleaning agent, and she kept it under her sink. And her child, her young child, got into it and drank it, and was seriously injured. So there was a civil lawsuit that followed against Ajax, and the thing was that the defense or Ajax was she put it in under the sink, you know, and it's her fault, you know, by putting it under the sink, and it was a fail to warn case that Ajax didn't have a warning on it that it could cause injury or, you know, along those lines. And on the testimony of the mother, they asked, would you have kept it someplace else if there was a warning on it? So that's beneficial to the plaintiff, right? The mom's going to say, well, absolutely. If it said harmful to children, I never would have placed it where my children could get it. And the defense argued that that was speculation. And the judge overruled it and let her testify to that. I would have put it someplace else. I would have locked it up. And there was a verdict against Ajax. On appeal, the appellate court said that was speculation because that wasn't a situation that she was presented with. So she would have to speculate as to what she would have done had the facts been different. She can testify, she could have been able to testify to what her reaction was or how she felt when something, because that's her personal feelings. But what I would have done had it been A instead of, or B instead of A, absolutely not. That's speculation.
Yeah, hindsight's always 20/20.
Absolutely. Well, not mine. My hindsight sometimes is 20/40. I don't even know what that means. I don't know if that made me look good or bad. Let's see. Let's do one or two more. I really had this narrowed down to the most common objections. We really already
William
got
said that he was going to go next if you wanted to volunteer.
absolutely. Absolutely. I want to hear another opening statement. What side are you on, William?
Prosecution. Can you hear me okay?
I can hear you perfectly.
Excellent. Okay, I'm going to give it a go.
Wait, before you go, I remembered something that Joey didn't do, and this is going to help you. She didn't say, may it please the court, counsel, ladies and gentlemen of the jury. She probably did it when she delivered it, but she was so stuck to reading it from her pad there, she just went right to the beginning of her opening statement. So please, always, that's a little, like a half a point that my judges are going to take off. When you start, the judge says go, you say, may it please the court, counsel, members of the jury. So go ahead, William.
It was, may it please the court, counsel, and ladies and gentlemen of the jury.
Ladies and gentlemen, or members of the jury, it doesn't matter.
Thank you, Your Honor. Counsel, members of the jury. Emil Rankin. I want you to remember that name. And I want you to remember that name because Mr. Rankin can't be here to tell you what happened to him. He can't tell you how he felt, what he saw, what he heard. We'll never know that from Mr. Rankin because he'll never be here to testify on his own behalf. So how will we find out what happened? Well, we have to turn to the evidence. And the evidence in this case will show that the defendant shot Mr. Rankin 3 times and Mr. Rankin died. Let me say that again. No one in this case is going to dispute those facts. Mr. Rankin shot 3 times and the defendant shot him. But why? The defendant was dispatched to Mr. Rankin's home to collect a $250 gambling debt. The defendant wasn't there by happenstance or by invitation. And that's really where the story begins. The evidence will show that the defendant walked into Mr. Rankin's home uninvited, demanded payment for the gambling debt, ordered the defendant, a stranger, out of his home. Mr. Rankin said, "Get out." A witness will testify that at that time, the defendant said, "Have my money by tomorrow at 6 p.m. or I will personally blow you away." Well, Mr. Rankin, for whatever reason, picked up a small ashtray and threw it and hit the defendant in the head. The evidence will show that the defendant was on his way out of the house when he was struck by the ashtray. In response, the defendant pulled a gun, a semi-automatic pistol, from his pocket and fired not once, not twice, but 3 times. And those bullets went into an area on his chest about that big around, about a 3-inch spread. You're going to hear that a police officer, Judd Wortham, he's going to testify that he's a marksman on the police department. And he would have difficulty putting those 3 shots that close together. That's important, ladies and gentlemen. I want you to pay particular attention to this. Because in order to get those kinds of shots off, there are a number of actions that you have to take. He had to pull the gun out of his pocket. He had to raise the gun, point it, pull the trigger, and hit with 3 carefully placed rounds a small target, all in a very short amount of time. The question will be raised as to how a person who is shot once remains completely still for the following 2. Perhaps the most important thing in this trial comes down to timing, premeditation. That means that a person has to think out what he's going to do. They have to think about doing what they did. Now, the law doesn't give a certain amount of time for him to achieve that decision process. Here, the defendant, again, went through a number of actions to shoot Mr. Rankin. Removed the gun, raised his arm, extended it forward, pointed it at Mr. Rankin, and pulled the trigger 3 times. He had already threatened Mr. Rankin. He said, "I'm going to personally blow you away." He's telling you right off the bat that I'm going to kill you. After that argument and the ashtray hitting his head, the defendant, all he did, he just moved up the execution date. Ladies and gentlemen, the defendant had threatened Mr. Rankin. He threatened to kill him. He went to the home with a pistol that he was carrying illegally and followed through on that threat a day early. Ladies and gentlemen of the jury, when you go back to deliberate, I want you to come back with the only possible verdict in this case, and that this was a premeditated murder. Thank you.
Loved it, loved it, loved it.
Thank you.
I want to say perfect, but I'm trying to find something that I can give you some constructive criticism. Let's go through it. I love the beginning. Remember that name, and then because he can't tell you, he's not going to be here, to tell you. So a good setup, to get into it. What I really like that you did, that a lot of people, because we have to cut to the chase in here, but you focused on the small amount of the debt, which is going to give you some. This was already, he killed a man over $250. What I loved most is you didn't argue. Okay, I was waiting for you to cross the line and argue, and you didn't. All you did was present the facts in a very persuasive way, and it's okay to be persuasive. That's different than being argumentative. Sometimes we think, oh, that's argumentative because of the tone of voice. Your tone was perfect. It was like matter of fact, and it was commanding. It was beautiful. It was beautiful. And I was like, okay, come on, say something argumentative, and you didn't. You were just saying facts. You were just presenting the facts. but it was very persuasive. And then you would pepper in cherry-picked evidence that supported, those things. You will hear, whatever, testify to this. You will hear, and boom, you would just, highlight the key facts that support your case very much without going into too much detail, without giving us too much, without being too long. So it was just absolutely beautiful. Using the language, I will personally blow you away. That's key. That's key evidence, and you got to get that in to your openings, and you did. I was waiting for you to say the evidence will show one more time because you did it twice, but you didn't. You didn't cross the line. See, Joey's back there thinking, oh, I heard him say the evidence will show, and the judge criticized me for that. But Joey, you did it at least 3 times, and that's where it was the 3rd time that I thought was too much. I will let you do 2. 2 was perfect. William nailed it with 2. If he had gone 3, though, I promise you that I would be saying right now too many times. Drop at least one of the evidence will show. So it's all right to use it, but then get more mileage out of it. The evidence will show, and then evidence, and then if you want to do another one halfway through, the evidence will show, and then evidence, and try to avoid a 3rd time. So good job on that. I want to talk about the 3 shots because this is going to be an issue in this case. You obviously are relying as the prosecutor on the close nature of the 3 shots to support your theory and your theory is premeditation, intentional, intended to kill him, and he aimed, he had to take it out, he had to aim, and that's evidence of premeditation, of intent, and those close-knit bunch shots prove that. Is there another way, though, that the shots would have been so close that supports the defense of self-defense?
Yeah.
I thought about that too. And what I had thought was that maybe they could say, well, he's got prior military training. He was trained to do that. He was a Marine. And in that instant, he pulled the, consistent with his training, did exactly what he had been trained to do. And those 3 shots landed exactly where they were supposed to in the heat of the moment in defense.
Are you presuming, though, what distance are you presuming that those shots are fired from?
Right. Yeah. That's
across the room?
Yeah.
Let me ask you this. If they were on top of each other, if Rankin had charged him and was within, a very close distance of him,
right,
is there any way that those shots would be anything other than very close to each other?
Yeah, that's one of those things that will definitely be argued because you got a moving target.
And this is such a great issue in this case because then you've got the ballistics of that there was no the gunpowder on the clothing, which backs you up, though I think only 1 to 3 feet. I don't remember exactly. It's been a while since I read it. But Mark, you want to comment on that, and I think that you have a very relevant comment.
Well, it's a Mauser, a German semi-automatic, or rather, it's an automatic. It can be either semi or automatic. And if it's an automatic, you only have to pull the trigger once and sustain it, and you'll get off 3 shots rapidly, and they'll hit the same spot.
Somebody asked me, and I apologize for not to the whole class. We're going to presume it's semi-automatic rather than automatic. So I'm going to take that. That's good thought. I like that. But I'm going to make him. It's one of those that I'm going to exercise some creative to make him have to pull the trigger actually 3 times. But what I want you all to go back and look at is where was the body found? Where was Rankin's body found? And that's going to support the close distance. His body was found close to the door. He initially started out at the table where he was playing cards, but the body was found close to the door. And assuming, we don't know, but assuming, he dropped and died where he was shot, then that's going to close the distance. And there's no conclusion one way or the other. It gives us the opportunity for the prosecution to make argument related to the facts, and it gives the defense the opportunity to, make these facts kind of go both ways. Joey, you had your hand up.
I did because one, I was going to say those facts aren't in evidence. There's no theory that he was being charged. There's the issue is that he was defending himself from an ashtray being thrown at him. My other point was that in his statement, he was saying that he was stumbling back. So he was on his way out the door, and then he felt this ashtray, and then he stumbled and he was falling. And so my thoughts were that how are you going to get 3 closely knit shots off together as you claim that you were pulling your pistol out as you were falling and then shooting him, bop, bop, bop. So that would be my point, or my counterpoint to that defense statement.
And those are good, and there's going to be, and that's why I think that these are intentionally picked so that there can be that argument back and forth. Let me just say though, let me comment on one of the things that you said. Gosh, I forgot now. What? Go back and how did you start out? Tell me again what you just said.
I said that. Well, the first point was that there were no facts and evidence.
Oh, right. Yeah. Thank you. That's right. Yeah. Okay. Well, I'm presuming that I'm setting up this argument for the end, and the defense can argue circumstantial. You know, it's a theory that's based on circumstantial evidence, just like the prosecution. For example, you might have a prosecution for murder where there's no evidence other than the defendant's DNA was found at the murder scene. There's no direct testimony that was there or anything else. So the prosecution is certainly not prevented from, in closing argument, saying that he killed him or that he charged him, or that he stabbed him, even though nobody testified that he stabbed him. So the defense can just as easily make argument based on the circumstantial evidence as the prosecution could. So that would be my response to that. The rest of it I agree with. And that takes me back, though, to one thing, William, in the end. I would like to see, I think it's okay. I'll let you get away with it, but it sounded too much to me when you finished it and you said, when you go back into that jury room, to me that rang as closing argument when they're about to go back into the jury room. Because that's when you usually say it. That's when I said it. That's when I saw when I see attorneys do it. They end their closing argument with that. And might even be more specific. You're about to go into the jury room, or in a few moments, you're about to go into the jury room. So to hear it in the opening, when the next thing that's going to happen is they're going to hear and see the witnesses, I would just take that out. You could, and it's so simple. You could say at the end of this case, because we do. I know what you were doing there. You were following the 10 Commandments that said that we want you to tell them what you want to do in the opening statement, and you do. But just take off that when you go into the jury room or when you're deliberating, just say at the end of this trial, after you've heard all the evidence, I want you to find him guilty of murder.
Yeah, I think the nerves worked in a little bit there at the end.
There was no nerves. You were so calm, cool, and collected. You currently are my favorite student because that was such a great opening statement.
Thank you.
Unfortunately, I don't think we have time for another one. So I promise you, we didn't take a break, and my promise to you from the beginning is, we don't take breaks, and we'll try to get out a little bit early, and we never do. We never probably will. But I'm going to go ahead and call it now. We will have plenty of time next week, okay? I'm done with objections, so we're going to jump right into anybody who didn't do an opening tonight doing openings. I do want you to start looking at direct examinations. In my opinion, direct examination is the easiest part. It's just how you're going to get, in a non-leading manner, the relevant evidence from each of the particular witnesses. And there's a difference in when on direct examination, the witness is the star. All of the words should come out of their mouth. You're just giving them a vehicle, an opportunity. Tell us what you did when. Tell us, whatever. And then they're going to tell, and the jury's going to be looking at them for the evidence. On cross-examination, you're going to phrase the question where you're giving the evidence, and the witness is simply agreeing with you and saying yes. So the show is going to be the show is going to be on the attorney in cross, but the show is going to be the witness in direct. So with that in mind, there is a 10 Commandments or something on the module for direct examination. Look at it, read the book, go to the outside resources. But this really is the easiest part. And so I want my twos, who are my prosecutors, to write a direct examination of Jones and a direct examination of Officer Wortham. I want my ones, who are the defense attorneys, to write a direct examination of the defendant, Harper, and a direct examination of the doctor. Now, ultimately at trial, I'll let you do more questions as long as you can keep within 10 minutes. But for this project for next week, 10 questions. So it's pretty simple. You should be happy about that. You're limited to, so that you really got to get to the point. Don't waste time. I'm exercising Rule 611A, you know, where I'm controlling the mode and presentation of evidence to avoid wasting time. So pick your 10 best questions, but follow some, you know, we want to know who they are, what they know, you know, why they know it, along those types of, you know, some structure, I guess is what I'm trying to say. But have
10
fun with it.
questions each, or 10, or like 5 and 5?
So 10 each, 10 each. Yeah, it'd be really hard to limit you to 5 of each of them. I think it's hard to do 10 of each of them, because you want to ask their background, you know, the officer, you know, where do you work, how long have you worked there, what's your assignment there? That's 3 questions. So if you only had 5, you know, I mean, you can boil it down. How, where you employed, how long you've been employed there, and probably get away with only 2 questions on background. But you got to have some background of the witness, and that's going to take up at least 2 questions. All right. Have a great night. Have a great weekend, and I will see you next Thursday. More openings, and we'll start looking at direct examinations. Don't hesitate to email me, text me, whatever you need if you have any questions.
Good night, Judge. Thank you.
You're very welcome. Thank you.
Thanks.